May I please, your lordship. Lordship, a prayer for listing a PA lordship, and out of same FIR, same forwarding report lordship already disposed of, and another matter, and tomorrow matter, item number serially 5 lordship. Can it be lordship tomorrow? Tomorrow. Obliged, lordship. Obliged.
May I please, your lordship? Lordship, beg to listing for a bail application for today, your lordship. Earlier rejected by this honorable court, security produce over, your lordship.
My lord, item 24, I was checked, CD is not available, my lord, AB.
CD not available.
Item
24.
24.
24. Scan copy received. ma'am.
So scan copy is there.
Next week, any date, my lord.
No interim order. Adjourn for the day, list it next week. You want a date?
Any date, my lord, as for the convenience of this court, my lord.
It will be on 31st.
Obliged, my lord.
May I please, Lordship? Lordship, beg to mention item number 18, my lord. Concerned with the other city, my lord. Matter may I send for the day, my lord.
Item number
18, my lord, yes.
8.
18.
Or 18. Submitted, that with the consent of the other side. The matter may be adjourned for the day. You want, when should I fix it?
After 1 week, my lord, any date.
Let it be after 2 weeks, November. 7/11.
Obliged, my lord.
May I please, your lordship? Your lordship, back to mention item number 37, your lordship. The conducting council IS Laskar is on bereavement, your lordship. So can it be on 29th, your lordship?
37, my lord, case diary not received.
City was there. As per last order, city must,
CD is received.
CD, but my lord, today CD is not with me. I will have to check, my lord.
city was there.
Anyway, my lord,
As per order, it was to be retained.
then next one.
Leading counsel is stated to be in bereavement, adjourn. You want it after next week?
Next week, 29th, is it possible, your lordship?
His mother,
Yes, your lordship.
mother.
Yes,
Mother.
29th. Similar prayer with respect of item number 52, your lordship.
52 की bail hearing में 52 also, my lord, case diary not received.
Similar prayer, 52, same date, 29.
Much obliged.
May I please, your lordship? My lord, I am praying for listing one criminal petition, lordship. It was filed on 15/10.
Okay,
Not
yet
listed.
listed. Kindly mention before the senior bench.
My lord, senior bench, court number 21, that court will not sit today, lordship, that has been declared. So,
May I please, your lordship? I beg to mention item number 48. The
48. Yes.
48, the respondent in person is not well today. We have informed also other party. So adjourn the matter.
Okay. With the information to the other side.
24 position.
Read that respondent in person. 6 another date as he is unwell. Prayer is allowed. When should I fix it?
After 1 week,
Let it be on 3/11. Is it okay? 3/11.
oblige your lordship.
My sincere apology, my lord. Wrongly, I have mentioned the case number, my lord. Instead of 24, it will be 32, my lord. 32, and then interim is there, my lord.
अच्छा, third, no,
32. my
30
lord.
doctor. 24 number to one. 24 number.
See, I was.
32.
Yes, my lord.
32.
CD not received, my lord.
CD not received.
CD not received? 32 here, huh? 30.
I'm
CD
the-
not, no,
See,
already,
already,
CD not received?
yes,
Interim bail stands extended till the next date of this date. Which date we had given?
on 13/11, my lord.
30,
13/13/11. Already petition
Oh.
is in interim.
13/11.
I'm with
13,
you,
11.
lord.
May I please, lordship, prayer for listing, lordship, a criminal revision petition, lordship. 2 matters, lordship, for
Tomorrow?
admission.
Tomorrow?
No, 2 matters,
The senior bench is on leave today?
not fit today, lordship.
Not for today.
Lordship, 28 or 29.
May I please, your lordship? My lord, I filed a bail application, my lord. That may be listed tomorrow, my lord. Obliged, my lord.
May I please, your lordship? I beg to mention item number 36. Today CD was called for.
Mhm.
Maybe
May I
CD is
please?
not received.
CD not received.
Inform it, you for the,
No, no, my lord.
Just, let me complete.
36 CD not received, my lord.
36,
Earlier I am on interim. Your Lordship.
case diary is not received, issue reminder, 36, interim stands extended, list on
On 14/11, my lord.
14/11.
Obliged to.
May I please, your lordship? Lordship, I'm praying for listing of an AB, my lordship, for tomorrow, my lordship.
Okay.
Highly obliged.
May I please your lordship? Lordship, I beg to mention item number 47, my lord. In this matter, the other side has filed written objection today itself.
Acha.
So, my lord, can it be called in the record, my lord? And the matter may be fixed in the second half, my lord.
Yeah, record, the objection will be brought into the record.
Okay.
Let's see whether we are able to reach it.
Obliged.
You should we can take it.
Yes, ma'am. Obliged.
Lordship, I beg to mention, appear for a listing orders, orders matter. Criminal appeal.
May I please, your lordship? I would like to mention item number 50, my lordship, prayer for withdrawal, my lordship. As instructed, my lord.
Item number 50. Mr.
D. Hussain, my lordship.
D. Hussain.
Please, as instructed.
D. Hussain, you are one of the
No, my lordship.
councils.
I have been instructed by Mr. I.H. Lashkar, my lord.
D. Hussain,
Yes, my lord.
learned counsel appearing on behalf of the leading counsel I.H. Laskar, submits that they have instructions to seek withdrawal of this matter. The prayer is allowed. Bail petition stands disposed of on withdrawal.
Highly obliged, my lordship. I'm grateful.
May I please, your lordship? Lordship, I beg to mention for urgent listing of a correction in bail order, which was passed on 17th. Lordship, senior bench is not sitting, therefore I beg to mention for tomorrow.
May I please, your lordship, I'd like to mention item number 19, your lordship. Matter be fixed on 30 of this month, your lordship. The engaged councilman Jadalan is out of station, your lordship.
19,
19.
yes, council is out of station, list on, you kindly inform the other side,
Yes, your lordship.
kindly inform the other side.
And your lordship, item number,
List on, can it be on 31st,
yes, your lordship.
30 or 31st?
Yes, your lordship.
31st.
And your lordship, item number 45 of court number 21, your lordship. 21 is not sitting today, your lordship.
25, I am taking. 21, I
Well,
am
notice has been
No.
given, your lordship.
So let's see, let's wait. If it comes, we'll adjust it.
May I please, your lordship?
Obliged.
Sir, list. Lordship, I am praying for a listing on IF for tomorrow, lordship, for correction of.
May it please, your lordship, my lord. My lord, item number 56, my lord.
56.
My lord, today we have some personal difficulty.
Inform the other side. Kindly inform the other side. Have you informed the other side? No, not yet.
No,
Kindly inform the other side.
my lord.
We'll adjourn it, but kindly inform them. Inform the other side.
Yes, ma'am.
When do you want it? Next week?
Next week, ma'am.
3/11. Huh? Adjourn for the day, 3/11. Inform.
My lord. Obliged, ma'am.
May it please your lordship? May it please your lordship? Lordship, I beg to mention for listing a bail application for motion for Friday, lordship. The petitioner is 84 years old, lordship. Obliged, your lordship.
May it please your lordship? My lords, I beg to mention item number 29 for court number 21.
That list is not here before me. Not yet. I don't have any instructions. Is it written in that list that I'll be taking up? Anyway, we can adjust it later also in the course of the day. Don't worry.
Lordship, with due consent of the other side, I'm appearing on behalf of respondent number 1 and 2, S. Hawk. Lordship, matter may be adjourned for the day.
Which matter?
Item number 15, Lords.
15. Mr. Hawk,
S. Hawk.
learned counsel appearing for the respondent side submits that with the counsel of the other side. He seeks an adjournment of the matter. Prayer allowed. List on 4/11.
Obliged.
Sorry, well, item 21 of court number 31, na? Item 31
I don't have that list, sir.
of
I
court
don't-
number 21.
I don't, huh? Okay. I don't have that list before me. It has not yet come. Instruction has not come.
But if it comes, kindly, it may be
Okay,
taken.
I'll adjust it. Okay, you want it to be taken? Taken, yes.
May it please your lordship, this is a regular bail application
offences alleged are under section 87 of BNS read with 8 of POXO. Your Lordship, on the last occasion, notice was issued and an
Fraudulently disassembled the money. He has fraudulently taken that money. The allegations are false. At this stage, Lordship, I humbly pray that the case diary may be called for, Lordship. Lordship, a date may be fixed, Lordship.
Right. You are Mr.
Dr. P.P. Methi, Lordship.
P. Medi, Learned Counsel. P. Bothakur. Call for the case diary of, it is, what is Simla?
Shimla Police Station, Lordship.
Which district?
Buxa, Lordship.
Simla Police Station in the district of Simla PS case number 50 of 2025 under section so and so. Section, the accused was stated to have been arrested on 9/9/2025. This is the matter on any suggested date?
On
From your side?
311.
311?
Lordship.
3.
I'm obliged, Lordship.
An FIR is filed on 6/8/2025 at page 12, Lordship. POXO is there, Lordship, therefore Lordship may issue notice and for the case diary.
Behind the bars since 52 days. So behind the bars since 52 days. So kindly consider my detention period, Lordship, and
When was it last rejected?
reject at page number 42. Was rejected on 17/9/2025.
Quite a while. Investigation might have been completed.
No,
officer.
madam.
Meantime,
No,
updated case diary?
Yes, yes, madam. Updated case diary may be called.
Call for the updated case diary of Murajhar PS case number 109 of 25. The accused is stated to be in custody since
31/08/2025.
repeat of earlier bail petition. It is fairly submitted that an earlier bail petition
Rejected on
was rejected at this court on 17
17/09.
17/9/2025. In BA number 3014 of 2025. List the matter on
3010, madam. 30.
3010.
Deep level.
May I please, your Lordship? A regular bail application, Lordship, NDPS matter, Lordship. Quantity that was seized was 13.5 gram on page 23, Lordship. Inventory and arrested on 10/6/2025. As on today, Lordship, it is 133 days behind the bar. Although the case is registered under intermediate quantity, Lordship. Lordship, at that stage, the learned code below, Lordship will find on page 27, Lordship. Due to part charge sheet was filed without the FSL report on 62 days, Lordship. On 62 days, Lordship, on page 27. May I read, Lordship? The record reveals that the police recovered 27 numbers of vial from the possession of the accused containing contraband drugs, and the concerned IO finding incriminating material against the present accused filed charge sheet white CS number 106/25 dated 31/7/2025 against the present accused under section 61(2)(123) of BNS read section 21B of NDPS Act, but without collecting the FSL report, Lordship. Lordship, just to keep the accused person behind the bar, Lordship.
No, this issue
Without-
actually, in another connected matter, which is resolved, and I'm working on this issue. Actually, it has been referred to a larger bench of the Honorable Supreme Court. This issue has been referred to a larger bench of the Honorable Supreme Court. So in the meantime, what shall we do? That is the issue we have to decide,
Yes,
right? So some because it seems that there are different viewpoints being taken. So at this stage, this issue, you can just get the this thing, scan copy of the CD and charge
Yes,
sheet.
yes.
And not within a not shorter time frame,
Yes.
comparatively.
Whereas the embargo of
time.
37 also does not, is not.
This will not
there,
apply
Lordship.
because this is intermediate quantity.
Intermediate quantity.
Yes, madam,
Lordship,
without FSL report already, madam,
Charge
submitted.
sheet is filed.
So, madam, at this stage, from the, madam, registry will call for the scan copy from the file.
Lordship, only concern is that
And regarding FSL report, I will get the instruction.
Technically, charge sheet has been filed, but
Yes.
whether it can be taken to be a completed charge sheet
Yes,
for the purpose
yes.
of
Yes, madam.
for the purpose of statutory period.
Statutory period.
This is the issue.
Yes.
because call for the scanned case diary and scanned charge sheet of Golpara PS case number 108 to 2025. So and so under so and so section of the NDPS. The accused was arrested on 11/6/2025. Drawing attention to the order dated so and so.
Order dated 12/8/2000.
12/8/2025. Passed by the learned session judge Gwalpara, rejecting the bill. They submitted that charge sheet was submitted in this case within the applicable statutory period of 60 days, without, however, filing the FSL report. List the matter on. What are
My lord, third 311.
311.
Lordship, only thing is that although the charge sheet has been laid, it is not registered as an NDPS case. So Lordship, CS number may be referred in Lordship orders. Lordship, CS number is 106/25, Lordship.
CS number 106 of 20. Yes, thank you.
Deeply obliged.
Dated 31/7/25.
Deeply obliged.
311.
Article 6, petitioner is behind about 59 days today. 60 days is mandatory. Losses, Susted also not submitted. NDPS, losses. 10 kg ganja recovered from the,
After some time, my lord, I will get the instruction. my lord.
at 2 p.m.
Good, sir.
May I please your lordship? Lordship, this is charge sheeted matter and this is under POCSO matter, lordship, no notice.
Notice will be issued. Okay. S.C. Borra, learned counsel, and D. Botaku. Call for the scanned case diary and scanned charge sheet of
My lordship,
Boginodi PS case number. Yeah.
My lordship, it's already raised under special
Yes.
POCSO.
Boginodi PS case number 30/2025, which after submission of charge sheet has been registered as special POCSO case number 130/25 and pending before the court of the learned special judge POCSO, Lakhimpur. Under section so and so to DD1, the accused is stated to have been arrested on 6/6/25. Call for the scanned copy of case diary, scanned copy of case diary and charge sheet of the aforesaid case. Also taken steps for notice upon the informant, right?
My
And
lordship,
pleaded as respondent number 2. Notice shall be served to the concerned police station. Place the matter on.
my lordship, can you?
On my lord, 411.
Hold on. My lordship, I might be wrong, my lordship. My lordship, if my lordship call for the scan copy of the records, then if there is in the order, it will, if evidence or anything, then it would might come. Instead of
Okay.
this, case,
Scan CD, charge sheet and scan copy of deposition statement.
if any, my lordship,
Deposition statement.
must
Deposition-
oblige my lordship.
Depositions. Otherwise unnecessarily. it gets-
Is my lordship,
Sometimes order sheets are relevant, but usually this will do.
my lord, my lordship,
For
oblige my lordship,
which date we fixed? 4/11.
411.
Is it okay?
my lordship, oblige my lordship.
Please, your lordship. Lordship, the petitioner is arrested on 31/8/2025. The FIR is at page 16. The allegation is that the petitioner and two of his workers were converting one dumper into a tanker, and a blast took place. And therefore, case has been registered under BNS and Petroleum Act.
So while converting blast took place.
So Petroleum Act and Explosive Substance Act also. So my humble submission is that CD may be called for lordship.
Third,
D. Chaudhary.
D. Chaudhary, learned counsel, and P. Botaku. Call for the case diary of Sivsagar PS case number 119/25, the section, so and so section, read with section 23 of the Petroleum Act. The accused persons stated to have been arrested on
31/8.
31/8/2025. List the matter on.
Lordship, one more prayer. One connected AB is also pending out of the same FIR. That case is fixed on 31/10. So along with the.
List the bail application, list on 31/10/2025 along with.
AB number 21
AB
40
number 2140 of 25.
25. Much obliged.
Please, your lordship. It is a pending investigation, lordship. They were arrested on 25/9, lordship. Lordship, 162 gram of morphine has been recovered, lordship.
Intermediate quantity,
No, commercial, lordship.
commercial quantity, sections are 21B there.
Sorry, lordship.
Oh, you have written. Can you call?
21B, lordship,
Just
21.
cross check. Intermediate quantity.
Intermediate, lordship.
Investigation is going on.
Yes, lordship, pending investigation, lordship.
25 on. D. Mehdi, Learned Counsel. Call for the case diary of NCB got crime number 12 of 25 under section 8C and so on. Accused was arrested on 25/9/25. Place the matter on. You are appearing
Lordship.
for the NCB. I will record your name. Good name, please.
N Kakoti, Lordship.
N. Kakoti. When should we fix it? When, any suggested date? 3/11
Lordship.
or it will be, you want it earlier or 3/11?
No, it's okay, lordship.
Okay.
Deeply obliged, lordship.
May I plead, your lordship, 483 application, your lordship. Lordship, in this case, the petitioner is behind the bar for 16 days in a bailable offense, your lordship. And the FIR is on page 17, page 11, your lordship. 21A of NDPS Act, your lordship. And the FIR is registered under 21A 8C of the NDPS Act and read with section 123 of the BNS. 123, the ingredients of 123 is not there, your lordship. May I read the FIR?
Just a minute. What is 8C? 8C is this,
8C is prohibition, your lordship.
8C, prohibit, knowingly acquire, possess or use any property which was derived from an offense committed under this act. or
No.
under any other
No.
clause.
Lordship.
Prohibition. of
Possession and sale
certain activities.
versus,
It is not a standalone offense.
lordship.
It's not a standalone offense, is it? What, no punishment is provided?
No, your lordship, only prohibition, your lordship. And
With some other section.
lordship.
In violation of this. Okay, 21.
And
It
check.
is obviously bailable. It is
Bailable,
within
yes,
jurisdiction of our High Court. And
Lordship.
BNS 123.
123, your
You want to
lordship.
read the FIR?
Lordship.
Okay, 9/8.
Long FIR, your lordship. This is to inform you that from reliable information was received from a source by OC Rupohiat PS Nagaon, Assam, at 7:20 PM, dated so and so. As per the information, one habitual drug peddler, Afan Alam, was transporting NDPS substance from Tetelia South towards Rupohiat for selling in various villages to the young generation under Rupohiat PS. Accordingly, general diary entry was registered as so and so. I, along with the OC Rupohiat PS Nagaon and staff, used departmental vehicle bearing registration number so and so at 7:25 PM. Along with government digital weighting scales, etc., towards Gunawari. We reached at Gunawari at about 7:40 PM and waited for the arrival of Arfan Alam. And the petitioner before lordship is with Arfan Alam, your lordship. Nothing is recovered from his possession. After approximately 20 minutes, a person noticed the police presence and attempted to flee. He was apprehended and identified himself as Arfan Alam, 18 years, address so and so. In the meantime, some local people gathered at the spot with local VDP, and I approached the following 3 persons who are already present at the PO, and they were requested to be witness during the search, to which they agreed to be witnesses. I identified myself on behalf of the police party and issued notice under section 50 NDPS Act to the apprehended person, namely Arfan Alam, regarding his body search, and he agreed. Accordingly, searched the whole body of apprehended person with the help of police party in presence of the above noted witnesses. During search, 18 number of small plastic vials containing suspected heroin, which was wrapped in a black color polythene bag, was recovered from the pocket of the accused long pant. The recovered 18 number of small plastic vials containing suspected heroin were weighed by government digital weighing machine and found 26.43 gram and with vials and 2.10 gram without vials. The recovered 18 number of small plastic vials containing suspected heroin was seized by the undersigned as per the seizure list in presence of the
Yeah.
presence of the independent
Okay.
lordship.
This present petitioner is Nasiruddin,
Nasiruddin, your lordship.
was-
He was with Arfan Alam.
but he's not,
He was not named,
he's
not
not
named.
mentioned, his name is not mentioned.
Not named. Lordship, that decision of the
One
coordinator.
twenty-three is, what?
Poisoning, your lordship.
Poisoning?
Poisoning.
Non-bailable.
Mm. Lordship,
123,
the ingredients of 123 is not in there, your lordship, in the affair. May I read 123, your lordship?
I'll just go through it, huh? No, actually, since there's some allegations that they were bringing the drugs to sell to people, that
Yes.
is why, by a little mistake, probably this section has been given. But this section will come only when somebody has
Yes.
administered
Lost.
or already
Ah,
taken.
lost.
Already taken. So anyway, so,
Lordship, there.
you have that.
Lordship, I have brought the judgment, your lordship. Coordinate bench of
We'll
this.
call for the, it's, give interim or call for the diary or dispose it of altogether.
Your lordship may call for the case diary. madam.
Lordship, I have the judgments, your lordship.
Yes, this one is the- Sir, this one is the-
Judgment of coordinate bench of this High Court, your lordship.
I know.
In
His name is not there in the FIR 123 edit to look other aspect of the matter only for that reason.
in Bilal Hussein, your lordship, paragraph 23. Paragraph
In
23.
Bombay High Court,
Nothing.
it has been held to be non-bailable.
That's it,
But
ba-
our High Court, this is more elaborate discussion.
Lordship,
Para 23
in Bilal Hussein, it has been elaborately discussed. your lordship.
discussed. 123 is non-billable, right?
Yes,
Billable.
non-bailable, 123.
So this will be maintainable because at least
Yes.
one non-billable section is there.
Because
Regarding as because my lord, there is nothing in the FIR and regarding the present petitioner, so only CD will reveal my lord, how, why 123 is there, my lord.
But from the FIR, your lordship, there is no ingredients of section 123, your lordship.
That's true. That's true, that's true. The instant heard F, Saint Leonard Council, the petitioner and P. Botago. The instant application filed under 483, seeking bail for accused Nasiruddin, who stated to have been arrested on 6/10/25 in connection with Rupahiya PS case number 277 of 25 under section 123 BNS 21(8)(c) of the NDPS Act. Peruse the Azahar with the assistance of the Learned Council. Azahar dated 9/8/2025. The gist of the allegations is about recovery of 2.10 grams of suspected heroin from the possession of the named accused Arfan Alam. Stop. The present petitioner is not named in the FIR, but he was He was apparently with the named accused at the time of his arrest. The learned counsel has also submitted that on a bare reading of the FIR, the ingredients of section 123 BNS pertaining to administering of poisonous or intoxicating poisonous substance or intoxicating drugs are not made out. Prima facie, I find force in the said contention upon perusing the FIR. Full stop. Under the jurisdiction of this High Court, this court, the coordinate bench has held offences pertaining to small quantity under the NDPS Act to be bailable. In this regard, reference may be made to the case of Amir Ali versus State, BA number 472 of 23, and Bilal Hussain versus State, AB number 3029 of 25, within bracket. Para 22. Full stop. The said para 22 may be reproduced here in the. Thus, I find that while the penal provision of section 21A of the NDPS Act is bailable, constitutes a bailable offence under the jurisdiction of this court, semicolon, the as far as section 123 BNSS is concerned, which is non-bailable, the ingredients thereof are prima facie not made out. Therefore, should we call for the case diary or dispose it of straight away?
Yes. Otherwise, my lord, case is registered under small quantity. 123 is there. His name is not there in the FIR.
In the aforesaid circumstances, I propose to dispose of this bail petition by allowing the sale. The accused, Nasiruddin, is therefore allowed to go on bail of rupees 20,000 with one surety of the like amount. The satisfaction of, actually, it is a bailable offense. This order has anyway.
And trial court also, my lord,
Ingredients are not available, but since 123 is there, so you take a regular bail.
Not.
15,000 with one surety of the like amount to the satisfaction of the concerned learned, and subject to the condition that he shall cooperate with the process of law. He shall cooperate with the investigation, shall not hamper or temper. I'll keep this.
Lordship, deeply obliged, Lordship.
Sometime.
After some time, let him go through. Yeah, you go through.
Tomorrow or day after tomorrow?
I thought today only you wanted to do.
Only
Today
I-
is not possible.
Yes, my lord, only FIR is to go, my lord. Can you see my FIR is
Take
is 15, my lord.
then CD may be called from.
Just a minute. You are for the informant.
Informant.
Kindly see page 15, my lord. Kindly see page 15.
Let me see if no submission.
Nothing
is required
in
from your
the-
side at this stage, then I'll see the FIR.
My lord, page 15, my lord, kindly see. Nothing in against the present petitioner, my lord. Present petitioner is accused number 2, my lord, who is the father of accused number 1.
Let me read. FIR dated 4/8.
Yes, my lord. With due respect, I have the honor to inform you that my minor daughter Muriam so-and-so is a student of class so-and-so.
For that, the present accused petitioner and the informant are the own sister, lordship. Page 11 in the FL, lordship. Vernacular marriage, lordship.
Page
11. Married, lordship.
Honman Hokare.
Yes. বিনীত সম্মান সহকাৰে আপোনাক জনাও যে আজি ইংৰাজী 17/7/2024 তাৰিখে সন্ধিয়া 4 মান বজাত মোৰ মা দেউতা মা দেউতাৰ ঘৰত মই আৰু মোৰ ল'ৰা আছিফ আলী আৰু ছোৱালী আসিফা বেগম একেলগে থাকো। তেনে অৱস্থাত মোৰ ভনী আবেদা বেগম মোৰ ছোৱালী মূৰত ইটা মাৰি দি মূৰত গুৰুতৰ জখম কৰে, ফলত কেইবাটাও চিলাই দিব লগা হয়। ইয়াৰ উপৰিও মোৰ ল'ৰা আসিফ আলী চেপা মাৰি ধৰি মাৰি পেলোৱাৰ চেষ্টা চলাই আৰু বিভিন্ন ঠাইত জখম কৰা হৈছে। Lordship, the incident happens within the family, Lordship. They are the own sister, and the victim are the niece of the prisoner petitioner, Lordship. And soon after losing the affair, the informant realized the fact, Lordship, and thereafter they entered a settlement, Lordship, amicable settlement. That is, I have annexed one affidavit. This is page 14, Lordship.
Yeah, why POXO is given?
Lordship, I am surprised, Lordship.
No. Mister, your good name, please.
KK Das, Lordship.
KK Das, learned additional PP. Full stop. Scan case record is available. However, not however, further. Service is completed.
Service complete, Lordship. It is in my, I have just received it in my WhatsApp.
Oh, it is submitted by the learned prosecution that service upon the informant is also complete. Stop, as none has appeared. Therefore, M.K. Brown, learned counsel, appointed as amicus curiae. The petitioner shall serve her a copy, to serve her a copy. And we can take it up. We can take it up after tomorrow, or day after tomorrow. Tomorrow, day after.
No,
But,
Lordship, 25. Copy need to be served.
Yeah,
24 times.
you have to give a, kindly furnish a copy to maybe amicus curiae. M.K. Brown.
24.
appointed.
24th, I won't be available, Lordship, so maybe 25th. Okay, Lordship.
20th is holiday.
Oh, sorry, Lordship.
Just to.
28, Lordship.
28th?
Maybe on 28th, Lordship.
List on 28th then.
Much of it.
25. Scan copy all.
In this case, Lordship, scan copy not received.
Lordship, on 2 occasions, the Honorable High Court had directed the lower court, but still the scan copies are not yet been sent. The accused, she is currently under judicial custody for 899 days.
890?
Yes.
What case?
This is regarding the POXO case against the.
My please, Lordship. The charge sheeted case, POXO is there. 27A is also there, madam. Today FSL report received, madam.
27A is there.
Yes,
27A.
27A will invite 37.
Yes.
Regards of 37. Anyway, let us proceed step by step. 65 days is completed. No?
65 days, Your Lordship. May I go through the FIR, Your Lordship?
At page?
At page number 11, Your Lordship. May I read the FIR?
Go ahead.
Sir, this is to inform that based on specific information received by reliable sources that a NDPS activity takes place in Bulandahar area. Accordingly, OC Hojai, PS, made a GD entry dated 17/8/2025 and prepared a team to do needful against the drug peddlers, and I, along with other police staff, as per GD entry number 16, proceeded towards this spot along with all necessary tools. The following police personnel were present. We left the PS at 12:42 PM by departmental vehicle towards the spot As per source information, we have arrived at Pachim Dablong in the house of Toibur Rahman and apprehended one person, namely Moriam Bibi, 38 years old, which was dealing with drugs at his house, Your Lordship. OC Hojai PS already authorized me to take the search in her body. So a search was made by observing all formalities of NDPS Act. During search of his house, we recovered total 26 number of plastic vials containing suspected to be heroin, 11 numbers of empty vials, total cash 58,430 rupees from his house. Accordingly, I weighted all the vials, found 31.27 grams of suspected heroin along with the vials. Thereafter, I seized all the vials and cash rupees from the possession of the woman Moriam Bibi, 38 years, who is the sister of Toibur Rahman, on presence of witness, and packed the same. After completion of all the formalities, I along with entire team and the seized suspected to be heroin and other exhibits and the apprehended woman departed and arrived at around 2:40 p.m. After that, I had handed over the seized items which were sealed and packed at the spot in presence of witnesses. Seizure lists along with the FIR. As per information, the persons Toibur Rahman and Moriam Bibi is involved in financing of illicit traffic of NDPS by providing funds for purchase and transportation and import of NDPS from Dimapur into Assam and its subsequent areas. Sale to general use of drugs for consumption by method of concealed distribution network. It may be mentioned that I, being the Sub-Inspector of Assam Police, is empowered by the government of Assam by notification under the provisions. It is to be noted here that the below named apprehended person habitually doing drug business and has been spoiling the society by doing such act of illegal activities. Your Lordship, here, as per the FIR and the forwarding and the case at large, the lady is not a resident of the place from where the drugs was recovered, Your Lordship. Her house is another 15 kilometers, 15-20 kilometers away. This is her brother's house where she has visited for as per family visit, Your Lordship.
This Toibur is our.
Toibur is our brother. Now, Your Lordship, the entire FIR and the forwarding and the materials on record clearly indicate that there was nothing recovered from her body in person. Whatever recovery happened from the house of Toibur Rahman, that is her brother, Your Lordship. Here, nothing was recovered from her possession, neither her handbag, neither her carrying bag, nothing, Your Lordship. It was recovered when her brother was not at home, she was at home, and the police raided, and she is not aware about the contents of whatever material was been recovered, Your Lordship. There is no conscious recover or possession from her as a person or in person, Your Lordship. Thereafter, Your Lordship, police investigated, and the calculation which was carried ahead with the vials and the measurement of the drugs is around 31 grams, but without the vials, it is roughly around 15 grams, Your Lordship. Intermediate quantity already 65 days behind the bars, Your Lordship. The area is not her. She is not a resident of that area. She only came to visit her brother's family. When the police raided, her brother was not at home, Your Lordship. This is the entire incident and the entire case at large, Your Lordship. FSL is also present. May my length of detention may be considered, Your Lordship.
FSL is.
FSL received, madam. FSL confirms that those contrabands is heroin, madam.
Investigation is going on.
Investigation is going on, madam.
Your Lordship, with regards to 27A, that is attracted as per the narration against the brother from whose house it was recovered. And I am not neither the custodian of the house, neither am in any authority inside that house, Your Lordship.
21B is intermediate quantity, right?
Intermediate quantity.
Yes.
Along with the vials also, if it is calculated, 5 grams and
Intermediate
250 grams. Even if the vials are calculated, it is 31.27.
Intermediate quantity.
Yes.
31.27, which is intermediate quantity.
And it is such a
5
small
grams
quantity.
to 250 is this thing.
Commercial.
Intermediate.
Such small grams, Your Lordship, because
So that is all. The
hidden
interest-
somewhere in the house, Your Lordship.
Only 21B statutory period is 60 days.
60
right?
days.
But 27A has been.
27A is, my
So
lord.
as far as I
Yeah.
know, if I'm not mistaken, 27A invites 37.
Yes, 37, madam.
Let us check it again. Let us check it again. Be sure. 18A and 27A and commercial quantity. I
Yes, madam. Punishment for financing illicit traffic.
Sorry,
and ongoing-
19, 24, 27A, and also involving commercial content. Anyway, so whatever it is, it has been given. That has to be seen then. So we have shown, the prosecution will have to just I praised the court regarding the materials with regard to 27A because this is almost,
Your Lordship.
it's over.
Further,
Whatever it is, recovery is there.
Recovery is there. Recovery is from the residence of the Toibur Rahman.
When was he arrested, this person?
18-8, Your Lordship.
18,
18-8, Your Lordship.
therefore 65 days.
Both are brothers and sisters, my lord. Yes, from the residence of the Caesar list, from the residence of the Toibur Rahman, those contrabands were recovered. And thereafter, there are 26 numbers of small plastic vials containing those contrabands and 11 numbers of small plastic empty vials also recovered, and amount of rupees 58,430. So those, my lord, Caesar list available, my lord. And regarding the present petitioner Moriam Baby was also present at that point of time. And from the investigation till now, my lord, investigation is going on. As per investigation, it reveals that, my lord, both Toibur Rahman and Moriam Bibi both were involved in, my lord, since long they are involved in continuing, my lord, this business, my lord. Your lordship may kindly.
Yes, 37 determination is a very
Indeed.
strong
Yes,
determination.
my lord,
right?
otherwise, my lord,
Once
investigation.
a positive determination is made by under 37, difficult, it will be very difficult to get bail. in
If an
future.
FSL report.
Financing aspect kindly.
Indeed, Your Lordship.
help
I'd
the
like to
court.
submit on that also, Your Lordship.
Yeah.
Your Lordship, with regards to 37, the rigors conduct that I am not an habitual offender. There is not an FIR against me previously. Furthermore, I am a woman in a part of the society and there is no flight risk with regards to my escaping the law, Your Lordship.
No,
So,
no,
would the-
37 will require the court to hold that with regard to this section, there are no materials.
Yes.
Indeed, Your Lordship.
Hmm.
Investigation is still going on regarding other aspects, my lord.
Because just giving a section, it should not be that IO should not be encouraged to just give a section to attract 37.
Yes,
There should be some
otherwise-
supporting mechanism.
Indeed.
From the case diary, my lord, regarding that any witnesses regarding that these persons are involved.
I think the best will be you take some time, some more time, you go through, only focus on this.
Yes.
Recovery is there, Caesar witnesses, some support is there.
Some,
He's undergone 65 days, that's okay.
I may be allowed to.
On the
return-
basis of that,
Yes.
that we may grant bail, may not
Yes.
grant bail, that is another matter. But as to check the statutory bar, whether it applies or not, kindly specifically see what are the materials with regard to 27A. If it is
Indeed.
there, then we have to see whether the test is passed,
Yes.
this side or that side. If it is not,
My,
then it's not.
my lord, I may be allowed to just say any, my lord, within a very short period, my lord, 1 week time, I may be allowed to return back the case diary for of this.
Your Lordship, that
And regarding, otherwise, my lord, I will have to get present status report.
This is updated,
updated.
22/8.
22/8,
On the last date, Your Lordship, only FSL report was called for.
because
And then the question of determination was supposed to be settled today, Your Lordship.
That's true. FSL report must be positive.
FSL report for the received, man, FSL report.
Anyway,
confirmed.
let us keep that original plan only. You
Yes.
just spend some more time and
Yes.
see it, and then if possible, we'll take it up in the second half. If
Indeed.
you feel handicapped by the investigation so far, then we'll
Yeah.
call for that.
Yes.
We'll call for an
Regarding
update.
27A, so far, my lord, I would like to, my lord, say, my lord, I have not found till now, my lord, in the case diary, my lord, because investigation is going on. I have not found any such
Check it once.
sufficient.
You can cross-check it once.
I will again cross.
Necessary, but 28/8 is quite long back.
Yes, yes.
That is also true.
Indeed, Your Lordship. Much of that.
That is also true.
And
That
regarding my
is
lord-
that also, that is also not irrelevant.
And
what you are
regarding
saying.
Moriam Bibi, but
That's-
regarding.
It is 22/8,
Yes, yes.
you know.
Regarding Toibur Rahman, my lord, that is anticipatory bail, my lord. Otherwise, regarding Moriam Bibi, my lord, he is already in jail. So regarding
This is the original FSL report.
original
I
FSL.
think you should keep it. I think. Keep a photocopy maybe. Anticipatory bail, I think,
That
would not
is-
be justified.
Regarding
May not be
Moriam Bibi,
justified.
my lord, your lordship, considering
Because
the,
there are materials and 27A is also there.
as
Of
because,
course,
my
with
lord-
anticipatory bail also 37 has to be checked
yes, sir.
if the sections are attractive. So in any case, you just flip through it once.
Yes.
And then.
Hey, your lordship may fix it day after tomorrow, my lord. Or tomorrow,
tomorrow.
day after tomorrow. in progress. I'll get specific instruction from the IO, my lord, regarding if there is Any specific material regarding that?
Yes, yes.
Which attached 27A, my lord, till now?
Yes. Otherwise, you should get the benefit. The FSL report has been received by the public learned additional people. The case diary is already available. The learned prosecution shall take necessary instructions and appraise the court regarding the investigation with regard to section 27A of the NDPS Act, which is one of the penal provisions given against the accused persons. List the matter tomorrow.
Yes, sir.
Much obliged, your lordship.
Case diary be written, CD be written.
Much
FSL report, you better you keep a
Yes.
copy and then you
Yes,
send it
in the case.
tomorrow. Tomorrow, kali ki tarikh ho? Commercial quantity,
Yeah, no, my lord. Intermediate.
C is given here. Just a minute, sir. Come to you.
Yes, well, commercial, sorry,
Commercial quantity.
commercial, 75.4 kg.
75
0.4 kg, man.
of,
Cannabis, man, ganja.
yes.
Commercial. Yes.
As per, as per section 50 of the NDPS Act, it provides a mandatory procedural safeguard during a personal search for illegal drugs. It protects an individual's rights by ensuring the search is conducted with fairness and legitimacy. Now, no investigation is made in the house of this petitioner. Kindly see, my lord, page 11 of the, my lord, notice for ground of arrest, page 11, my lord.
Okay.
My lord, column number is 12. Page 12. You further admitted to having carried and transported cannibals on multiple prior occasions to various states again under the instructions of prime accused Akash Agarwal, thereby confirming your habitual and organized participation in illegal trafficking activities. Lordship, never he was involved and no case was ever have been filed by the authority against this cultivator. Lordship, what happens? They have made the grounds. Lordship, page 11, column number 2 may be seen, madam. Column number 2. You were responsible for carrying 75.4 kg of cannabis, ganja, and subsequently handed it over to the co-accused Bapi Sarkar, Navadas, and Sanjay Singh for transportation to Uttar Pradesh via the New Delhi Rajdhani Express, train number so, New Delhi, allegedly at the behest of the prime accused Akash Agarwal. This is the probably statement made by the co-accused. It is stated in this report that he has handed over it, but no search was made in his house, and he was arrested. My lord, I have made this statement in paragraph 3 that while he was cultivating in his field on 21st July, he was arrested suddenly. And lordship, now search has to be made in the house of the petitioner. Now, probably on statement of the co-accused, because there was a clash with his father-in-law and with Sanjay Singh regarding some sale of land. So Sanjay Singh, as per my information, Sanjay Singh has probably made this statement before the police against this cultivator. Lordship, kindly see, then at page 15, the order of the learned court, trial court, page 15. Today was fixed for necessary order on bail of petition number 1 for accused Rahim Ali. Heard learned counsel for both sides. Brief fact of the case is that on 19/7/25 at about 7:38 AM in New Delhi, Rajdhani Express train, ganja was recovered from the accused persons and accused Rahim Ali. Facilitated the handover to of ganja, hence this case. Now, allegation is that this petitioner has facilitated. How he has facilitated and where he has facilitated and to whom he has facilitated. They have given name of 4 accused persons to whom he has handed over his ganja. While he was cultivating on his field at 10 AM, the police had arrested him. And the ganja was recovered from the train at 7:30 AM. Now, Lordship, he has already completed 90 days, 91 days. Then the my lord page 17 may be seen for a while. This man has been was suffering from seriously from many days. My lord, the certificate issued by civil hospital, my lord, originally in the handwriting, my lord, 17. This is certificate that Rahim Ali has 30 years, son of Rahim Ali, the son of, name is typing mistake, son of Rahim Ali, Hatigao, Panel district, Udalgiri, Assam, has been suffering from anal fistula and urgently he needs to get admitted for surgery. He was under my treatment from last few weeks and for further treatment, I have recommended him to admit to the Guwahati Medical College. But the handwriting copy is at page 18.
Yeah,
Page 18. Now, Lordship, regarding illness, the appeals court held that when there is the medical report and an accused is in the jail for a long time, my lord, interim may be granted for his surgery. And then if necessary, he may be directed to surrender before the police again. Lordship. So let him get the operation be done at the Guwahati Medical College Hospital, my lord. And if necessary, your Lordship may direct the police and direct the petitioner to surrender himself before the concerned police station at Panel. It is already 90 days over. And section 50 provides that if the investigation is made in the house and recovery is made in his house, case is different. It was an imaginary story made by this, my lord, police. And my lord, on the statement of co-accused, my lord, the appeal should held that on the statement of a co-accused, generally bail should not be rejected. The statement of the accused.
Attorney, oh. Keeping this. The case is, where is the FIR? Yes. Look at the FIR. Or I can look.
There is no FIR, my lord, only police has sent the ground arrest.
No, there will be an FIR in this case.
Maybe, my lord,
We have to see it from there.
I do not know, Lordship.
No, there will be an FIR.
I have seen that the police.
FIR is here, but in the case there is
FIR
FIR.
There has to be.
Oh,
The initial allegations I wanted to see.
Yes, ma'am, FIR.
Investigation is going on, no? CD has been
Investigation,
received.
investigation is going on from the position of my lord 3 persons. Bapi Sarkar, Nabo Das and Sanjay Singh, those contrabands were recovered. And thereafter, my lord, the total 5 persons were arrested in this case, one Akash.
Those 3 persons, where it was found from their position.
Yes.
In
from their
Rajdhani
position.
Express.
Yes, they were supposed to, my lord, transported those, my lord, contrabands to Uttar Pradesh, my lord. Those contrabands were recovered from their position in, my lord, New Delhi Rajdhani Express. And my lord, main allegation against the petitioner is that, my lord, the present petitioner is the person on being instructed by one Akash Agarwal, my lord, he delivered those contrabands, my lord, ganja to the present 3 accused persons, my lord. And since earlier the accused persons is involved in delivering those contrabands, my lord, ganja, my lord, to the persons, my lord. And he is involved, associated with this business since long, my lord. And from the investigation, it reveals that there are, my lord, this is an interstate gang of, my lord, involved in trafficking of ganja, my lord. Total 5 persons till now arrested. Akash Agarwal also arrested, my lord. One main accused person, my lord, Bijoy Kumar Agarwal, not yet arrested. And the mobile phone of the present petitioner, my lord.
Are there any materials other than the statement of co-accused?
Now as per the note of the IO, furthermore, the mobile phones of the accused persons, including Rohim Ali, the present petitioner, my lord, have been seized and sent to the Forensic Science Laboratory for analysis. The FSL report is awaited and its findings are expected to play a crucial role in the ongoing investigation. So mobile phone of the present petitioner, my lord, sent for FSL analysis, my lord. So that report will reveal, my lord, further evidence against the accused person. That is the, otherwise, my lord,
The CD is updated, reasonably updated.
16/10/25.
Outdated.
Till now against the accused, my lord, other accused person's statement, but
Only.
regarding that mobile phones, my lord, only FSL analysis report will reveal
is true.
further. Last, first page, my lord, a brief note of the IO regarding the investigation is also there.
You see the FIR first. You can have a seat.
Yes, sir.
I'll take some time.
To give mobile mallet as per instructions, he was asked to give the mallet the fare of the rickshaw. And he has sent it by, I think, online, to the Sanjay Singh. Fare of rickshaw, because he traveled by the said rickshaw. And the fare of rupees 30, 40 rupees like that.
Have a seat. You can sit down. You'll have to see it because commercial quantity section is there. The allegation is that he acted as a middleman
Yes.
between that said Akash Agarwal and these three.
On being instructed by Akash Agarwal, he delivered those.
The only materials against the accused is statements of co-accused.
Till now,
Will the section rigors of section 37 be attracted? Because
my lord,
because at the trial that is ruled out, right?
yes, my lord, because this is the stage of investigation. So at this point of time, my lord, definitely I am an investigating agency, have no other option. And otherwise, that FSL report regarding the mobile analysis of the accused person. Not only one single.
There are materials against these two who were arrested from the railway station,
Yes.
no doubt. Have you flagged the portions pertaining to the present accused?
Yes, my lord, regarding that, your lordship may kindly, last note already I have read out to your lordship, my lord.
Just one.
Till now, only statement of the my lord, it is-
Fair enough. No, both us. He stated that he carried it for 5,000 rupees.
Yes, yes.
Mentioned as unknown person. Only for 5,000 rupees due to financial difficulty, he agreed to carry, knowing that it was,
For every trip, my lord.
knowing that it was, it had drugs. Just. And they are caught now.
And regarding my lord, last trip, that is the note of the, regarding sending.
I will see.
Doing officer report regarding contrabands received.
His name emerged from the statement of this Akash Agarwal. Because these other three are, three people who were caught in the police station, they have mentioned as unknown person,
Unknown person is,
whatever it is.
yes.
But his name emerged from the statement of Akash
Akash,
Agarwal.
Akash Agarwal. And his accused statement is also there, my lord, Rahim Ali, he also admitted, my lord. I have trademark statement of the present accused. Since earlier, my lord, he has transported on behalf of Akash.
His statement would not be admissible, but. Further statement. Further statement. Third, Assistant Learned Council for the petition. Additional P. Bothakur for the state. The instant bail application has been filed under section 483 BNSS, seeking regular bail for accused Rohim Ali in connection with Bongaigaon GRPS case number 86 of 2025 under section 20B. The case arose out of Ben is FIR dated ... Such my name. FIR dated 19/7/2025. The gist of the allegations is that on suspicion, the luggage of 3 persons, Vapi Sarkar, Navo Das and Sanjay Singh, within bracket co-accused, were checked and found to be containing suspected ganja, which after weighing revealed 75.4 kgs. Full stop. The name of the present accused, Rohim Ali, emerged during the investigation, and he was so arrested during the investigation on 21/7/2025. As part of the investigation. The Learned Council submits that he has already completed 91 days custody, and he's also suffering from health problems in the nature of anal fistula, for which he has been suggested for urgent surgery. Full stop. In this regard, a copy of a medical certificate issued by Medical Officer Kharopetia CHC has been annexed, and I peruse the same. In support of the contention on health grounds, the Learned Council has relied upon a decision of the Honorable Supreme Court rendered in the case of Satyendra Kumar Jain versus Directorate of Enforcement, 2023 SEC Online SC 680. In the said decision, the Honorable Supreme Court, in the facts of the case, accepting a medical report from GB Pant Medical Institute, allowed interim bail to the accused for a period of 6 weeks to undertake treatment at a hospital of his choice. The case diary is stated to have been received. The Learned additional PP fairly submits that the incriminating materials so far are in the nature of the statements of the co-accused who were apprehended at in the railway station, along with the statement of another accused named Akash Agarwal, who is alleged to be one of the kingpin in organizing this racket of interstate trafficking of narcotic drugs. Full stop. I have perused the relevant portions of the case diary.
while arrest memo. The IO also, Lordship, could not comply the mandatory guidelines, Lordship, as per section 36 of BNSS, as well as directive of the Honorable Supreme Court, Lordship. Your Lordship, although 4 witnesses already examined, Lordship,
Including victim informant.
including victim, informant, Lordship.
This,
Only thing is that as per office note dated 22/10/25, service report is awaited, Lordship. 16/10/25, Lordship.
I was just thinking that probably.
16/10/25, Lordship, office note dated.
Can copy receipt, but not. Let him quickly take the instruction, isn't it?
Next date, any date, Lordship.
My lord, short date kindly, because already 4 witnesses are examined, Lordship. And also there are violations of law, Lordship.
Show me that, this thing.
My lord, arrest,
47 notice not followed?
my lord, at the time, arrest memo was not prepared as per mandate, Lordship. So, page 21, Lordship. Page 21 is the arrest memo, Lordship, under section 36 BNSS, which was not attested by the Lordship petitioner, and also no near relative signature was there, Lordship. Only IO prepared that, Lordship. And there are no signature taken.
This, Goswami,
That's
this
it.
will not do for this. If this is the 47 notice, this will not do.
47/22 pages.
Yes,
Lordship.
Lordship.
This will not do. Just cross check if it's the same one. Must be the same one.
Same
For our
one, yes,
satisfaction.
I have checked it, yes. I have said already, yeah, that is the.
Same.
Yes, sir.
So this will not do. So on this ground, he will be entitled to get bail. This will not do. Shahjahan Ali,
Shahjahan Ali,
19 years.
19 years, Lordship, young boy, Lord.
Whatever is the law should be followed. IO should learn. Now it will not be justified for
Yes.
any IO not to make mistake. We all make mistakes, but these are well trained. A lot of training has been given also.
All
But
have been
earlier, at that time, when was he arrested?
arrest on 17/3, Lordship,
17/3/25.
2025, Lordship.
And it was just emerging. Not so clear.
And medical report also does not reflect any types of, because on 73 itself, medical.
Informant, actually on merits, also he has a ground because victim examine already informant exam. Informant is not there, but since this is a case of.
Next page, ground of arrest of their Lordship, but
They have given.
they have given, but
It has to be just put here.
it is also some. Forty-eight notice.
During recording of statement, victim.
Next, fix the next date possible after.
No. So what is this then? What is page 23?
My lord,
Page 20 is the second page of the ground of arrest. 47 notices.
Second page. Here they have written something.
They have written sometimes.
They have written
that,
a reason during recording.
Possibly sexual intercourse with her.
Case of complete non-compliance.
Complete non-compliance.
It's not a case of complete non-compliance. They have written something. About 48 notice.
48 notice, yes.
48 is their, Lordship, page 25, Lord.
48
Same
there.
line, same sentence was written.
Ground of arrest is
Sufficient evidence found and accused found. Some ground has been
intercourse
given.
with her
That
against
should
her
be
will.
person
That is
specific.
true. That is true. Some ground has been given. This is not zero compliance, but some compliance is there, but it should be a little more detailed.
Details.
So in that case,
And he was informed as that why he has arrested Lordship, particularly. And
in recording of the statement of the victim girl, he stated that the accused namely so and so. Police section. If this is the only one, then it will not suffice. I saw only this one actually.
that later part was there, Lordship.
A letter, but only this
So-
one will not suffice. But this might suffice little bit.
Little bit ground of arrest.
should be
there.
more.
More should be more.
Yes,
Alarm
person
should be-
specific, Lordship.
As per the specific.
Zero compliance. Can you quickly take the instructions?
Yes, Lordship.
Then we'll complete the
Yes,
formality.
day after tomorrow if possible, Lordship.
Day after
Through
tomorrow,
over
Lordship,
phone
because-
also, Lordship.
because-
he may take
because
instruction.
we have to communicate
Those
and then I'll take
290
instructions.
They also have their loads, right?
He is 19 years
Speak
boy,
to him.
Lordship. 19 years boy, Lordship.
Hmm.
Young boy, Lordship.
But still, it's a POCSO. Look at it from the point of view of the victim also. The Learned Council submits that the petitioner is in custody since 17/3/2025. In the meantime, 4 witnesses have also been examined during the trial, including the petition, the informant and the victim. The scanned case record is also available. However, service report upon informant not yet received. The learned additional people shall take instructions from the concerned police station regarding such service. Monday?
And 5, 6 are the brother, own brother. And 2, 6, 7 is the wife of the brother. And my number is in serial number 5, page number 10. What happened, my lord? I and my wife went to Arunachal, my 7 years old daughter keeping my eldest brother's house because she was going to school, my lord. And my lord, on 22 January, my sister-in-law, that is my husband's brother's wife, informed me over telephone that
50, my lord. FIR is page, my lord, relevant part is page 13. It's a long FIR. I want to read out, my lord,
Quickly, quick.
important para, my lord, page 14. My lord, page 14. From the top, my lord, first paragraph.
No, I'll be able to read it.
My lord.
I'll read it.
Lord, here is, my lord, total suspected heroin was recovered from the 8.6 gram with vial, my lord. So 5 gram is below, up to 5 gram is, my lord, small quantity. And if we, my lord, it is weight with the, my lord, plastic vials. And if it is, my lord, weight without plastic vials, then it will come under, my lord, small quantity, which is available, my lord. So as on today, my lord, 50 days he is in the behind the bar, my lord. At this stage, my lord, I may be allowed to go on bail, my lord.
Yes.
And
8.6 with beer.
8.06.
8.6 with plastic vials, my lord.
How can we find the weight without the vial? Is it-
Here I have checked the entire case diary, even the order of the my lord trial court inventory.
Sampling, it can be.
Yes, sampling everywhere, my lord, only 8.6 gram with
Everywhere.
vial. Everywhere, but nowhere, my lord, there is any mention about without vial the
It
weight
will
of
be a
the.
little less, but whether it will be less than 5.
Yes, yes, but it
Still.
cannot be said that also, my lord, because whether it would be, my lord, come below, my lord, 5 gram or not.
Yeah, that cannot be said. That's true.
No,
It's
only
very
on, only on the ground of length of,
investigation.
only on the ground of length of detention, otherwise, my lord.
Otherwise, investigation has.
Investigation is going on, your lordship, may can.
The allegation is that he's selling. That is a problem.
Yes.
But
Consumers are
actually-
encouraged to be rehabilitated. But sellers
But
From my experience, I find
Yes, yes.
most sellers and consumers, they are also, most
He-
consumers are also selling.
There is
but
no
I am
problem.
categorically my lord denied that
No,
part.
he,
Like,
he's peddler, my lord. From investigation, he's peddler. There is no.
Because they have to take out their, realize their money for consuming. Initially, actually, they are primarily drug consumers.
Yes, yes.
Yes.
Would really realize their expenses of drug consuming, they
Yes.
start selling in small quantity.
And at that point, they could have raised at the time of before the trial court also, they would have filed an application that, my lord, those.
but but the decision my lord Stringent Act my lord as per my lord each and every procedure have to follow very strictly my lord.
An order of the, my lord's trial court at the time of drawing of samples inventory, my lord.
And my in support of my case my lord in paragraph 6 I have stated my lord some lines my lord.
So. Before the break, IOC, Learned Counsel for the petitioner, and P. Botako, learned additional people. 483 bail application and seeking bail for accused Roham Ali, alias Roham Ali. Bongaigaon PS 229 of 25. The section, and so. The allegation, the Azahar FIR dated 1/9/25 is about recovery of suspected heroin from the position of the present accused petitioner. Quantity of which is stated to be approximately 8.06 grams, inclusive of vials, VIALs, vials. The case diary has been received. The learned prosecution submits that investigation has revealed incriminating materials against the accused, also indicating that he is involved in peddling. I perused the case diary. It appears that investigation has progressed and is pending for collection of FSL report. In view of progress of, despite the adverse materials, in view of progress of investigation and length of detention, Dash allowed to go on bail of rupees 30,000 with one surety of life amount. Satisfaction of the concerned learned court. Concerned learned court will be.
Special judge Bongaigaon my lord.
Bongaigaon. And subject to the conditions that number one, he shall not hamper or tamper with evidence. He shall not abscond, and he shall not misuse his liberty to commit any illegal activities, including any activities prohibited by the NDPS Act. Return case diary, stands disposed. After the break.
Well, the applicant is, my lord, very ill, my lord. He is behind bars.
Keep
He
it
is
flexible, okay.
having some urgencies
Keep
there,
it flexible.
my lord. How will
Here, my lord, 61 days today, my lord. Last occasion, your lordship has fixed it on 61 days, my lord. And
Instruction is there.
Yes, my lord. Search it not yet submitted.
SM Molla, Learned Counsel, and P. Botako. Some conditions will have to be imposed, no? Because of the nature of the allegations.
My lord, my lord.
Some conditions will have to be imposed. You also convey to him not to disturb. The petitioner invoking section 483 BNSS is seeking regular bail in connection with Hajo PS case 357 of 25, under section so and so. He was arrested on 23/8/2025. Good stop. Diary was received earlier.
Diary received, ma'am.
The case diary was received on the last date. Full stop. Today, upon instruction, the learned additional PP submits that investigation is not yet completed. In the meantime, the accused, having completed the applicable statutory period of 60 days, has become entitled to default bail You've calculated, no, 61 days.
Yes.
Default bail. Accordingly, the accused is hereby allowed to do 30,000 with 1 due. Concerned, JMFC Hajo.
JMFC Hajo, my lord.
Concerned learned JMFC Hajo. And the following conditions are imposed. Number one, he shall cooperate with the remaining investigations. He shall not hamper or tamper with evidence. He shall not in any manner intimidate or harass or harm the informant slash victim and their family members. Stop. In case of violation of bail conditions, the bail would be liable to be cancelled. Return back is the bail petitions for disposed.
Obliged, ma'am.
The area has been received.
Case diary not received.
Not received. Case diary is not yet received. 28/8, he's in custody since the accused stated to have been arrested on 28/8/2025. Issue press reminder for the case diary of 3 PS case number 61 of 25. This statutory period will not be over
Yes.
on 20, if we fix it on 27th.
Yes. Otherwise,
Otherwise, it has to be at least on 27 lane.
yes, sir.
May it please your lordship. Lordship, in this case also the petitioner completed the statutory period, my lord. As on today, 63 days he is in behind the bar.
Kindly after some time, my lord, I will check once again. I will check once again after some time, my lord, if any other question.
May I please your lordship? Lordship, 63 days behind the bar earlier rejected by this honorable court, your lordship.
Statutory period is over.
Over, lordship.
Learned counsel.
Yes, as per my instruction, sheet not yet submitted. It will take some more time.
63, he was arrested.
21/8, your lordship. It is at page number 12, your lordship, that forwarding, your lordship.
Use the calculator, 21/8. Must be, you must have calculated. It's over, no?
63 days, your lordship, 63 days.
So আমার আগৰ order টো ললো 6 page 14 of first para is same, second para is same, third para is same, third parallel. An earlier bail petition was rejected by this court on 16/10/2025 in BA 3141 of 25, and a copy of the same has been fairly annexed with the bail petition. The learned counsel submits that the applicable statutory period is 60 days in the instant case, and the accused has completed 63 days as on today, and has become entitled to default bail if the investigation is not completed. Full stop. The case diary is not here, no? We did not call for the case diary. It's the
Yes.
first product, first day.
Yes.
First day.
First day.
The learned additional PP, Mr. P. Borthakur fairly submits that upon taking instruction, it came to be known that investigation is still going on and not yet complete. Thus, the accused, having become entitled to default bail, is hereby allowed to go on bail of rupees little higher, 50,000. 50,000 is one surety of the like amount to the satisfaction of the concerned learned court, which will be the court,
CGM Lordship Nagaon.
Nagaon,
Nagaon.
CGM Nagaon, and subject to the conditions that he shall cooperate with remaining investigation, shall not hamper or tamper with the shall not commit any illegal activities or offences, violation of bail conditions, until cancellation of the bail. The bail petition stands allowed and disposed of. The process does. Left on 54 no is any bail here. Supply 54. And
In this case, response was by party
Mhm.
and notice was sent to her. But office note indicates that it is, receipt notice has to be received, madam. And moreover, CD, up to date CD was also called for me.
Notice my lord served my lord already.
Definitely.
Notice served.
Office note of 29.
Yes, my lord, we have received the intimation, my lord.
Oh.
Notice served, notice served. my
up to date case diary you
lord. But case diary not yet received. my lord.
case diary not received. So
Amicus may.
we can appoint an amicus.
Yes.
As per, it is submitted by prosecution that notice upon the informant impleaded as respondent number 2 is complete. However, the case diary is not yet received. Issue reminder for the case diary. Further, the D.K. Bhattacharya. D.K. Bhattacharya is hereby appointed as amicus to represent the informant. His name may be shown in the cause list and petitioner side shall furnish a copy to the learned amicus. Is the matter on?
On my lord, 12/11. Yes, B, A, B, my lord. 7/11.
Is that okay? Little longer?
7th will be long, madam.
No interim, right?
There is no
I
interim.
don't know if it-
3/11.
If your
3/11.
timetable permits, 3/11, we can take a chance. Is also, the other case also is on interest? Oh my God.
No, my lord.
Yeah. it
In
is.
that case.
No, he is on. 34 also, he is on interest. So in that case, you get the updated case diary?
No, my lord, in that case also the petitioner is in interim, my lord.
Yes, yes. Both the cases, there is interim protection.
Yes, yes.
Both the cases.
May I submit, your lordship? In this case, when I inquired with my client as to whether he has given a statement, he told me that he went to give his statement before the investigating officer, but the investigating officer had clearly stated to him that the informant who had filed the case had filed an application before the investigating officer that he doesn't want to pursue the case with respect to the accused person, this accused person. That is my instruction. person, Your
Oh.
Lordship. That is why my
I will get
statement
the
was not recorded.
That may be reflected in the
Yes.
case diary.
Yes, my lord, that is not there in the
The
case.
present case diary is not updated.
Not up
It
to.
was here.
You should know that exam.
Hmm?
Statement
For
report for them.
The petitioner was granted interim protection on 22/7/2020. The updated case diary was called for, but it is not yet received. No, you have the case diary, right? You have the
Yes,
case
my lord, I have the
Case diary is called, the case diary is available, but
Available.
it is submitted by the learned additional PP that the same is not updated. And perhaps the updated case diary may be called for. The prayer is allowed. Return back the case diary and maybe procured again along with the up-to-date investigation.
May I also pray, Your Lordship, that I will be allowed to give my statement before the investigating officer, because I went there.
Oh, then it has to be recorded.
Yes, Your Lord.
In the next date of listing. In this context, it is submitted by Mr. Devi, the learned petitioner counsel, that though pursuant to grant of interim, the present petitioner had appeared before the IO, but his statement was not recorded on the ground that the informant has stated before the IO about not wanting to pursue the case against the present petitioner. So nevertheless, it is submitted by the learned counsel that the present petitioner may also be given an opportunity to get his statement recorded. Accordingly, the petitioner, present petitioner, namely
Neeru Jain.
Mr. Neeru Jain will appear before the on the same day.
Yes.
I'm very grateful. Your Lordship.
On 13/11.
13/11. Is it okay? 13/11.
Very grateful. Your Lordship.
May it please your lordship. This is an anticipatory bail application. This had come up before your lordship on the last occasion. This is a case which was registered under section 103, my lord, PNS, murder. And we had contended that this was a case of suicide. On the last occasion, though the case diary was there, it was not conclusive as to whether the death was homicidal or suicidal. So your lordship was pleased to direct that the case diary be sent back for updation. Now I believe the case diary has come, my lord. So here, my lord, the petitioners before your lordship are the father-in-law, the mother-in-law, and the sister-in-law of the victim. The victim was found in a hanging position, my lord. And we have, the informant on the last occasion had also very vociferously argued that it is a case of murder. We had committed murder. So subject to what is there in the case diary as to whether the cause of death is suicidal or homicidal, your lordship will examine that aspect. And the husband, my lord, the main accused, was arrested and has been granted default bail. Another accused has also been granted bail by your lordship. So now these three petitioners.
Husband has got default bail, another on merit.
Merit, my lord, and length of detention. And now the father-in-law, the mother-in-law, and the sister-in-law before your lordship. There are some allegations, my lord, of cruelty, because this case is also registered under sections 85, my lord, which is the equivalent of 498A.
Sorry. Sampu Bora.
His statement is available.
So maybe later he was examined. After,
But,
after his
no,
inspection, he went again, then he got examined.
Otherwise, my lord, the materials also there, only appearance, my lord. My lord, in this case,
What is the allegation?
allegations is regarding taking loan by several persons and not refunding that loan with fake document to the tune of rupees 45 lakhs. Several persons, but these persons will not help all these, those persons whose salary is around 17,000, 18,000 something. They approach this person. He may arrange all this and with the help of maybe the bank officials also. And he prepared fake document enhancing their salary and all this. And subsequently 7 lakh, 13 lakh, 10 lakh, this amount loan has been sanctioned to different persons.
Enhancing their salary?
Yes, yes, my lord. And
So
more-
this is of that taking loan.
Yes, and
Personally.
now none of these persons, 7, 8 persons are there, none of these persons has refunded the loan, not paying the EMI. And he is the mastermind. Two statements of the persons who yes. And some persons who were not the employee of the some company, taken the loan. There are statements of 2 persons, who approached these persons, and one person's salary is 17,000. He took the loan of 6,60,000, and Sampu Bora, for helping the process, he got 1,40,000 from that person. Another person who got the loan up to the tune of rupees.
His salary, the salary was inflated to 7 lakhs, 17,000.
No, already actual salary is 70,000, but subsequently it is enhanced and all this.
It was
But
inflated and loan of 7 lakhs was taken.
And 6,60,000 got the loan, and he is the mastermind. And IO has given a brief objection regarding that. His custodial intervention necessary because to some bank officials, maybe the bank manager and the person who verify the documents, he also may be involved. So his custodial intervention necessary, my lord. My lord.
But the petitioner before lordship is neither the beneficiary, my lord, nor he is in.
Some persons, my lord, they are not the employee of PWD, Oil India, they are not the employee. They are shown to the employee of that persons, and that is the brief note of the IO, and I have trademarked 2 statements of the loanee.
First, second, third, fourth. I got last order to Sibu. First, 1 to 4 same. This Nurul Haq was the main person originally, right? Who's named in the FIR.
Yes, but Nurul Haq is the agent of Sampu Bora.
I see.
He projected him. Yes. So I have trademarked two statements of the persons who got the loan. That statements may be perused. And antecedents of the persons, he has another case in the objection slip, my lord, in the second page, there, it is there, my lord, see. 46 of like 25.
That order I have annexed, my lord. Order granting bail, my lord, in item, my lord,
Yes.
46, I have annexed at
No,
page
so much
24,
input, but I don't know this.
page 24.
The case diary has been received along with a bail objection and stuff. The IO has contended in the bail objection that the present petitioner was found by the investigation to be one of the main persons involved in the racket of fraudulently securing loans from banks in the names of various persons by inflating their incomes inflating their incomes. It is submitted in this context by the learned additional PP that such inflating of income of various persons was also done in a fraudulent manner. And in this way, loans of almost 45 lakhs, loan of almost various loans of almost 45 lakhs was taken out from the bank, in which some bank employees are also alleged and are also suspected to be involved. Good stuff. The IO in the bail objection has objected to grant of the pre-arrest bail containing and submitting before the court that the custodial interrogation of the present accused petitioner is very much necessary to ascertain the involvement of other persons in the wider racket. Here is the statements of the witnesses and co-accused. I find force in the contentions of the prosecution and the IO. And I am of the view that this may not be an appropriate case for grant of anticipatory bail from the point of view of effective investigation. Accordingly, the bail petition stands rejected, thereby vacating the interim bail by order dated 17/9/2020. Return back the case.
My lord.
Obligation.
40 to 43 are same, my lord.
10, 40 to 40.
40 to
May I please, your lordships, same. Your lordship, 42, it is anticipated bail, your lordships. The earlier, the bail application of this petition was rejected by this noble court, your lordships. Now I come up with the other ground, your lordships. Your lordships, is 40, no? First FIR.
This for
First FIR, your lordship, the FIR upon which I filed this application, your lordships, page 40. Your lordships, in this case, your lordships, one thing may be considered. The file was display. So, yes. Here the allegation that accused persons are there at the time of your
the occurrence.
Occurrence, your lordship. This is the allegation. Now, your lordships, but the SI, this FIR was filed through the in charge, your lordship, Bhawanipur outpost. So definitely this person was not present at the time of occurrence. And whatever he gathered, your lordship, from the preparation of occurrence, he wrote this in the FIR. But now, your lordship, the person who present at the time of the occurrence, your lordships, page 30. Page 30, no? Page 30, your lordships. There is a second FIR here. First FIR regarding the date, your lordship, this FIR was filed by the person who was present on that day, your honor. The brother, no? Brother. Your
Second FIR over the same incident.
Not same incident.
Different
Incidents. It's regarding the, your lordship's assault. So here I am reading, your lordship, assault, no? Quarrel and assault. Here I am reading, your lordships. I beg to state that the above name accused persons house east side in my agricultural land, that in the plot of agricultural land, from the long time the accused and his brother used to grass their goats which destroy the crops. On 24/6/25, around 1 p.m. in afternoon, the above name accused person around 6 goats destroyed the crops
on the equivocal phase. When I informed the accused regarding the incident and warned him that such incidents shall not occur in the future, the above named accused got furious. The accused said slangs to me and my nephew, Muslim Haq's wife Kulsan Khan, and also gave threat to life. Thereafter, on the same day, at around 7:30 p.m., when the complainant was proceeding toward the Sukumant Bazaar, then accused person attempted to kill him with a sharp iron spike, but somehow I succeeded to save my life. However, on 26/6/25, at around 5 a.m., the accused person killed complainant nephew, father, namely Mr. Bahar Uddin, by stabbing a sharp iron spike in his body. Therefore, there is a delay in filing a file. So this incident, Your Lordship, 26/6/25 incidents upon which the FIR was registered, and this on the basis of that, Your Lord, everybody was implicated, Your Lordships. So this person was present in both the incident, Your Honor, but he never accused, given name of any other accused person, Your Honor. So my humble submission, Your Lordship, as he was present at the place of occurrence on the both occasion, Your Lordship. And regarding the first incident, second incident, Your Lordship, in the first FIR also, the narration is there, Your Lordship.
Anyway, so.
And last submission, Your Lordships, the recent development, Your Lordships, India. This economy, the one. Your Lordships, this accused person, the petitioner here, he is suffering from TB. TB. Recently, I come to Your Lordship. The positive TB, Your Lordships. Second page, Your Lordships. First page, 2000. I don't know.
It would first page of this.
Second page, Your Lordship. 4, Your Lordship, 4. Positive TB symptoms. So he urgently requests a second page. 1, 2, 3. Your Lordship, this one, this one, no? Regarding Your Lordship, Biban Ali. Here,
Just.
on Your Lordship. The prescription, medical prescription, Your Lordship, and second page. He is suffering from TB, Your Lordships. And regarding second, Your Lordships, second application, Your Lordships, 43, Your Lordship, the same incident, same fact, Your Lordship, his father is suffering, Your Lordships.
This person's son.
No, second, 43, item number 43.
Yes.
His father was suffering. Panic, there is a water in the lungs, and like that, Your Lordship, his father was suffering, Your Lordships. So this is the medical condition, Your Lordships. My humble submission here, Your Lordships, although in the FIR, Your Lordships, the implication by way of remark, Your Lordships, is there, but the person who was present at the time of incident, Your Lordship, the second FIR.
He has not mentioned about this.
Anybody names.
My lord,
Last was rejection was on 22nd August only.
Your Lordship.
yes,
It's a lapse. Investigation is not completed.
not completed.
Investigation not completed, Your Lordship.
PM, as per the PM report, death was due to hemorrhage and shock resulting to injuries sustained in chest. All injuries were antemortem and caused by sharp cutting pointed weapon. Now, as per the statement of witness, my lord, one Farhan Ali, my lord, he is the main culprit. But Farhan Ali fled away in a motorcycle. And subsequently, this Diwan Hanif Ali,
Kindly see, I'll just tell you.
Diwan Yar Ali.
Our petition, these petitioners are Diwan.
Diwan Ali Ahmed, Your Lordship,
Ahmed,
or
Diwan
Diwan
Ahmed.
Hanif Ali.
Diwan Hanif Ali.
Hanif Ali.
These two persons, you see the investigation after 22nd, especially. Especially after.
Yes, after
Especially, general investigation also you can see, especially after the date of last.
And Your Lordships, the person who in fact murdered, he was already arrested and enlarged on bail. Your Lordship.
Enlarged on bail, that is, my lord, on technical ground, 47, 48, not fulfilling that
Yes.
count. Not on merit.
Enlarged on bail, Your Lordship.
Not on merit.
Statement on
And furthermore, Your Lordship, in his statement itself, he himself said that I murdered.
Subsequent, subsequent to the rejection, my lord, investigation only regarding search of that those person and all this, my lord, nothing much. And as per the matter, as per the statements of the witnesses, my lord, main main culprit fled away with motorcycle, other 6% fled away running, seeing the other person. And out of those 6%,
He had contended, of course, but as per the investigation, all these were present at the place of occurrence.
yes, my lord, Hanif Ali, Diwan Hanif Ali, and other 4 persons were there, they fled away running. And main culprit fled away in a motorcycle. So at the place of occurrence, these persons were there.
Your Lordships, I have already indicated the second FIR, Lordships. The person who actually present, he's the brother of the deceased, Your Lordships.
No, the investigation is more important.
Your Lordships, now Your Lordships,
Sometimes,
if the main accused, Your Lordship, who actually murdered the person, Your Lordships, he's already enlarged on bail, he's out. What purpose?
On
What purpose it will be served, Your Lordship? This may be considered, Your Lordship. What purpose it will serve if I am behind the, I will go behind the bar, Your Lordships. Investigation is almost concluded because it is a murder by the main accused persons.
Last note of the IO, my lord, searching this.
they have been found to be absconding. They have not been found. They
No,
are-
yes, yes, last note of the IO is there, they are searching these persons.
But not found.
Last part of the my lord, diary. Searching all this, my lord. Last part of the diary. my lord.
Your Lordships, Your Lordships, based on the medical condition, Your Lordships, this may be considered, Your Lordship. This is the Diwan Ali Ahmed, he is suffering from TB, positive. And it is a contagious disease, Your Lordships. He required immediate medications, Your Lordships.
It's true.
I have also mentioned you.
In this one, same.
Yes, yes, same. Same, both the persons, my lord. One is
Your Lordship,
Diwan Ali and
on medical ground, Your Lordships.
Diwan Hanif Ali.
If I am suffering from TB, Your Lordships, in fact, it is infectious disease.
That's true. Anyway,
So, Your Lordship, both, my father is suffering, 143 father is suffering, he himself suffering TB.
22A order to first two paragraphs.
Please, Your Lordship, even on the medical ground, Your Lordships. I will ready to cooperate, I will go give a statement, everything, Your Lordship.
The allegation is about assault on the father of the informant with weapons, etc., resulting in his injury and subsequent death. Where is the original FIR? It is here.
Yes, Lords.
It's annexed.
Page 14.
Ah, The case arose out of an FIR dated 27/6/2025, wherein the aforesaid allegations were made. Full stop. 8 persons are named in the FIR, including the present petitioner. Full stop. An earlier bail petition was rejected by this court on 22/8/2025 in AB 1921 of 2025. Mr. Jha, learned counsel has drawn the attention of this court to another FIR dated 30/6/2025, lodged by Shahjahan Ali against one Diwan Farhad Ali, making allegations with regard to another but connected incident. In this context, it is submitted that the informant was supposedly at the place of occurrence, has not named the present petitioner. Nevertheless, it is also submitted that the petitioner is suffering from TB, tuberculosis, and therefore also his bail may be considered at this stage. The updated case diary has been received. The learned additional PP submits that as for the investigation, the materials, adverse materials have been found against the present petitioner as well. And the FIR name accused persons have been found to be present at the place of occurrence. And investigation has also found that after the incident, they fled away, and the main accused fled away in a motorcycle. In the given facts and circumstances, I do not find sufficient new grounds in the subsequent anticipatory bail application, which accordingly stands rejected at this stage. Return back the case diary. This will also be same. Same. Tuberculosis.
Second one only.
Your lordship, on medical ground, your lordship, TB.
Because nothing is there, serious allegations are there.
TB is a contested
No, he
disease.
doesn't have to be arrested. He may not be arrested at all.
44.
Next to same as same. No, common sense.
CD was called for.
I'm sorry, Malad, in this case, CD not received.
Not received.
He's an interim.
Interim. 44 case diary, not received. Issue fresh requisition. The interim bail granted by the order dated 25/9/25 shall stand extended till the next date of listing.
10th of November, man.
11.
11th of November, man.
11.
Number 6, timing.
Timing. You're ready?
Item number 6, my lord, as per my instruction, search sheet not yet submitted.
Today is
You got
59.
that, 59 days?
Yes, 59.
You have to give on merit only because statutory period is
Yes.
still not complete. So, Gogoi. 483 bail application seeking regular bail for accused Arun Behra, stated to be in custody since 25/8/25. In connection with Gopur PS, yes, 90 of 25 under certain subsection, NDPS. The allegation is about recovery of approximately, how much was found total?
10.185.
Approximately 10.185 kgs of suspected ganja from his possession. and stuff. It is submitted by the learned counsel, Mr. Gogoi, that in the meantime, the accused has completed 59 days in custody, and the applicable statutory period is 60 days, as the quantity in question is intermediate quantity. The learned additional PP, Mr. Botake, submits upon instruction that investigation is not yet complete. Though the statutory period of 60 days is not yet completed, but the same will be, same will be completed tomorrow. And the right to default bail will accrue in favor of the petitioner on 24/11. In the circumstances, I am of the considered view that on length of detention vis-a-vis the statutory period, the bail petition can be allowed. Accordingly, it's allowed to go on bail of 30,000 once severity. with the satisfaction of the concerned court, which will be Biswanath. Biswanath Sarli, Special Judge Biswanath Sarli. And subject to the conditions that he shall not hamper or tamper with evidence. He shall not commit any illegal activities, including any activities prohibited by the NDPS Act. Right? Bail petition stands disposed of.
Obliged.
Some instruction was there.
Yes, my lord, charge sheet not yet submitted, CD already, my lord, CD is here, my lord. The mandatory period already, my lord, for filing charge sheet already completed. my lord.
How many statutory periods?
Yes, my lord, 63 days is in
63
custody.
days. You know about it, alright. Mr. Ahmed,
UU Khan.
learned counsel for the petitioner, and did he brought up 483 application. Brijlal Jadhav. CID PS case number 18 of 2015. He was arrested on 21/8/2025. The case diary is available. It's available, right?
Yes.
Available, but the learned additional PP took instructions, took further instructions and submits that investigation is not yet completed. The applicable statutory period is stated to be 60 days, sure.
60 days.
60 days.
60 days. And in this context, the learned petitioner counsel submits that the accused has completed 63 days in detention and thereby become entitled to the fall bail. Accordingly, the accused so-and-so is hereby allowed to go on bail of rupees 35,000 with one surety of the like amount. The satisfaction of concerned learned court will be which court?
CGM Kamrup Metro.
CGM Kamrup Metro, CID. Subject to the conditions that he shall cooperate with remaining investigation. He shall not hamper or tamper with evidence. He shall not misuse his liberty to commit any offences. Violation of the bail conditions might lead to cancellation of the bail. The petition stands allowed and disposed of. Return the case diary.
Yes.
Deeply okay.
No, you've done. I did. Admission দিব? Admission to different. I'll take up admission matters if people say that they get delayed, otherwise.
May please your lordship, kindly pass over for time being lordship. My senior, Mr. D. Talukdar is another court lordship.
No, no, that's not a problem.
Time being.
Then. Also 15 is adjourned. It to 16 as a. Yes, it's the right.
Yes. My lord, this is a charge sheet filed under POSCO as well as IPC, my lord. Lordship may see the FIR at page 18. The incident took place 3 years. Thereafter, the FIR was filed. Informant Rajeshwari Sahani, aged about 19 years, Jindal Sahani, resident of the Grant, Lakhimpur district, Kachar, Assam. Accused Dilip Kumar Malla, 27 years. I beg to state that the accused is a wicked person. On last January 19, a love affair has been developed between me and the accused. I was minor then. The accused has sexual intercourse with me against my will and even raped me by assuring that he will marry me while I was minor. After that, I told him to marry me for many times.
May I please also crossing application against an NIA case filed by the son-in-law against the father-in-law.
Shall we try to dispose of or?
No, no, Lordship will fix the date of hearing, Lordship.
It needs a hearing.
It will take some
Some
time.
cases will, it is possible, but all
But
cases
this
not
will,
possible.
this
All
will
cases
take
not
some time.
possible. Or it will take lot of time,
Lot of
disturb other matters.
Other, Lordship.
If it is possible within a
Lordship will
reasonable
fix
time,
the date, fix
then
the
it's
date.
possible. But anyway, but you can make your introductory submissions.
Basically,
Interim order is
son-in-law
there,
has
no?
filed a complaint case against the father-in-law because they purchased, his daughter and the son-in-law, they purchased on plot of land. And there was marital discord, they separated, she filed 406 against the husband. Thereafter, some checks were there. He deposited a check stating that he has also invested in the land that she purchased. That I have got some documents to show that it was, she has paid the amount. So there is no legally enforceable debt so far, the father-in-law is concerned. So that's why, in nutshell, that is the case. So he'll also will admit it and fix a date for.
What do you say?
Your Honor, the subject legally
Hearing will
enforceable.
take its own time.
It will
Yes,
take
Your
time.
Honor. Legally enforceable debt and liability, Your Honor. It's a matter which can be decided only by adducing evidences, Your Honor.
There's some judgment also, I think.
Yes, Your Honor. It's not a small matter, Your Honor. Both sides
That's why
has
hearing
to
is
adduce
required.
evidences, Your Honor. So this is a matter of trial, Your Honor. Only trial can decide whether a legally enforceable debt or liabilities is there or not. So,
There's
Your
some
Honor.
judgment also.
No,
I think
apart from that, some
anyway.
documents they have annexed, from there I can show.
Now, we have also documents, Your Honor.
No, no, not that.
Already-
You have already annexed along with. the-
Already annexed.
From those I can
Then
satisfy your
we have
lordship.
to see two things. What are
Lordship.
those documents? And secondly, whether, what is the judgment? Whether it is it says in a binding nature, general nature, that, this legally enforceable debt per se is tribal issue and
It's
no
a
other
tribal
question.
issue.
Or whether it will also depend on the facts.
Depending on the facts and
Whether
circumstances.
we have to see that, these two
That-
things. we have
that's
to see.
what it is.
But it's an old matter also, 23, hearing has its own hazard, as you know.
No, no,
You
in
never know what will come. It has to be,
in a motion day, you can lordship, you can fix it in a motion,
motion hearings.
not in a part 2 list. In a part 1 list, you also can fix it.
No, we
Or you
fix
can
it
lordship can fix it in the admission column
on a hearing day.
on hearing day. That will be better. Let it be fixed in a hearing day on an admission column after 2 weeks.
No, I can fix it for hearing on a hearing day also, but it will come chronologically on that day.
Yes,
If older matters. will
Year-wise,
come
year-wise it will
Before
come.
that.
Year-wise it will come.
But criminal petition to 2023 is not a very new
Not
matter
in-
also.
Not
Cannot
too
be
new,
considered
not
a
too
very new
old.
matter also. Anyway, so whatever you suggest.
As per the convenience of the Honorable Court, Your Honor.
To petition heard the Talukder Learned Counsel, assisted by me. And your good name, please, sir?
Yeah. As Decca, Your Honor.
S. Decca, Learned Counsel for the complainant. Respond number 1, no?
Respond number.
The formal part.
That is the formal party, the criminal complaint case.
The petitioner is seeking quashing of complaint case being CR case number 1364 of 2023, pending before the learned JMFC, Kamrup M, Guwahati. Under the NI Act, under section 130, the full stop, the complaint has been filed invoking the provisions of section 138 of the NI Act. Full stop. It is submitted by the learned petitioner counsel. But his primary contention is that there is no legally enforceable debt between the parties, which is one of the foundational fact to invoke the jurisdiction under 138 NI Act. On the contrary, the learned counsel for the complainant, respondent, submits that the issue of existence or otherwise of legally enforceable debt might be a matter of trial. Full stop. In the given facts, let me admit this.
Admit.
Okay. The criminal petition is admitted for hearing. no fresh notice be served. Lordship. It appears that by the order dated 11/10/2023, further proceedings of CR case number 1364/23 are under an order of stay. Stop. The said interim order shall continue with the next date of listing. List on, we can fix a date.
Okay.
Sometimes we can take a chance also. On a hearing day, we will take it.
Basically.
9/12. Randomly, I'm saying.
9/12.
You check your convenience.
No, no, 9/12 will already.
9/12/2025 for hearing. List on 9 for hearing. It will come in the hearing. Sometimes adjournments are also taken.
No, no.
Sometimes a little bit of luck is.
That will
also
solve the
necessary.
problem.
Sometimes we may reach also.
We may reach on. Much.
Adjourn. 17 to here, 17. 17? No, it was 17 to dispose for you, no? Okay, dispose for the 16 to her, 18, 19, adjourn, sir. 20. Okay, Mr. Deore.
Yes, may I please, my lord? This is my application, my lord. My GMA application has been rejected, and the page number rejection order is there.
Up to date, Jima, otherwise,
report-
we'll have to see its
No,
correctness at that time.
No, my lord, actually in my vehicle, nothing was recovered as per the FIR.
This is the impugn order, 6/12.
Yes,
Strictly speaking, actually in a revision, Mr. Deore, as you would know also, in a revision, strictly speaking, we have to see that order, correctness of that order
Yes,
only, actually, and
Ma-
it existed, because
my
it
lord,
might have been justified at that time. Now things might have changed,
my lord.
and in 482, of course, you have some wider ambit.
The interesting part is that here,
From what I understand.
nothing was recovered from my vehicle, my lord.
It would be number one.
And they freeze it, and when they also freeze, there are certain procedures. There is a lapse of procedure, my lord. And for that purpose, I have preferred this application before this honorable court, quashing that order.
Oh, this is a new, this thing, this has another dimension, this case.
Yes,
So there's a freezing order. huh?
yes, my lord.
Hmm.
Three issues are there, my lord. NDPS, there's a section 68H notice, which I was not served. That is one. Secondly, section 68J, burden of proof that lies upon me. That's I was not given an opportunity at the time of hearing because I was already at the time, I was in the custody. And most important part is that section 57A of NDPS Act, where it is, the report has been submitted before the competent authority after 100 days. It should have submitted before 90 days, Your Honor.
Previous orders have called for updated as to whether it is required for investigation.
Yes,
Right? But this matter has another dimension. The IO said that I cannot release the vehicle because it is already frozen.
yes. my lord.
So I have to see actually, I have handled so many.
And otherwise, my lord, one recent.
68F,
Yes.
68F, let's see what it says.
and
No,
one-
my lord, if you can come to the 57A, that report of the first,
First
you know,
I
is
go to 57A.
57A. The report of seizure of the property of the person arrested by the notified officers. That's there. Whenever any officers notified under the section 53 makes an arrest of or seizure under this act, and the provision of chapter 5A applies to any persons involved in the case of such arrest or seizure, the officer shall make the report of the illegal acquired property of the such persons to the jurisdiction competent authority within the 90 days. This is very clear, my lord.
Here the IO,
So illegally acquired properties.
yes, it is not an illegal acquired property.
It may not be related to the vehicle involved in the alleged offense. Illegally acquired properties.
Illegally acquired.
Something like money laundering, something like that,
Yes, one.
proceeds
No.
of crime.
No. It's related to NDPS case only.
So, my lord, as per the provision of specifically, your lordship may kindly come to.
No, money laundering, I'm giving an analogy. It is
Analogy,
obviously
yes.
LDPS.
What-
Illegally acquired properties of the said person.
Yes, ma'am.
Then 60, anyway, let's see this.
68, my lord, F, my
F,
lord, very
Because
specific
the
provision.
order has reference to that.
Seizure or freezing of illegally acquired property. And 68 is,
68F.
68 is the identifying, my lord, illegally acquired property.
68F.
My lord, if it is illegally acquired also, there is a procedure, mandatory procedure is there that has to be complied. 68H, I was not given a notice, that is very clear. My natural justice has been violated.
But are you challenging this? You're challenging.
I am
the Jima
challenging the order.
And you're not challenging the freezing under 68F2? You're not challenging that? Aren't you also required to challenge that also? Just asking.
Yes,
Just
ma'am.
asking. You can make your submissions systematically, then point by point, and
Yes.
it will be easier for you.
Yes.
Let us go from the beginning and what happened actually, and then what happened, and how this Jima order came to be passed.
Yes, my lord, now, let me come to FIR. The relevant person may I read, my lord. Page number 2727.
Yeah. I found it.
Yes. I identify myself, that is the below third paragraph last, before the serial number 1, swift desire, that is. I identify myself before them and also offer them on behalf of the search party to the search before the searching research of vehicle. As they declined the offer, the search of the vehicle was conducted by me with the help of the police party in presence of the above mentioned independent local witness complying with the provisions of the section 165 NDPS Act, read with section 100 CRPC. During the search, the following were recovered. That means this is the first person where my vehicle was not, there was no connection with my vehicle, with the.
No, it was intercepted at Nakaseki, right?
Yes, this is the part. First part.
Just a minute.
Now, most important part is, my lord, coming to 28, page number 28. That just below after the entire operation. After completion of that is the police is doing.
Yes.
After completion of all the formalities, the police party departed from the PO at 10:30 AM and returned to the police stations at 10:40 AM on 17/1/2023, along with the seized item and apprehended persons, namely Meteksa Demari, age 28, son of so-and-so, village so-and-so, dated so-and-so. Then second person name is Dengo Boro, the age 22, son of so-and-so, village so-and-so, that Masbat only. Now, coming back to the most important line is the 5th line, sir, in my lord. During interrogation at the PS, the above noted accused stated that they were led by the 3 persons, namely Provin Basmotari, son of Sunil Basmotari, village Masbat, others village. The second person, Sweden Basmotari. The first person is the here petitioner, Ila Demari. In the vehicle bearing registered number AS12Z0718, in this vehicle, nothing was recovered, my lord.
Well, they said that they were led by three persons.
Yes,
in
means,
the, traveling in this vehicle.
there are two vehicles are separate.
Yes.
In one vehicle, the contraband was
was
being intercepted, it was
Oh.
recovered from there.
Yes.
And when those people are arrested, then they have they have said that we were being directed by the third person, by the petitioners and company. They have three persons, they were three persons. So in this vehicle, nothing was recovered and they were in fact not in Belmilo. That is the first part. Now, as per this section 20, as per the 57A, when illegal properties are seized, at least then within the 90 days, they should have
What is
reported.
the definition of illegal property then? We'll have to come to that. Illegal property.
Yes, here it is.
In that context, I'd ask this question that property acquired through
Yes.
drug trafficking or, through peddling of drugs, well, it must have been defined, right?
No, it is here on somewhere. I have come across.
Or if not defined, then we'll have to look elsewhere. Illegally acquired property.
Yes,
Let
madam,
us look for the definition. I don't think it is defined. I don't think it is there.
And second aspect, my lord, this vehicle is
Mhm.
is financed by Mahindra and Mahindra company.
No, that is, we'll come to that. No, we'll come to that.
Person illegally acquired property.
No, I don't think so. It is defined. So, what is the seizure order say? There must have been some orders regarding this freezing, right?
No, my lord, let me come back to another important aspect.
Yes.
That is,
Now, this
now,
this you have seen. So, from the statements of the interrogation statement, it emerged that these three persons were leading the
My lord.
contraband carrying vehicle with the help of this vehicle, right?
Yes.
Which belongs to you.
yes, my lord, that is. Now, as for the section 57A, what it says, within the 90 days, if it is illegal, whether it is illegal or legal, that is not the issue. They are using specifically the words called illegal. If the illegal property is being seized by the concerned IO, then this particular property, after seizing, they should have reported to the competent authority. Now, who is the competent authority?
My lord,
It is
Section 68BG, my lord, regarding illegally acquired property, my lord, in relation to any person to whom this chapter applies, my lord.
68?
68B, my lord, subsection G, my lord.
Oh, yes. It is
Illegally
defined
acquired.
here.
Yes.
Yes.
Oh, it's a forfeiture. This is a chapter, 5A.
Yes. Yes.
Yes.
Forfeiture or illegally acquired property.
G, small g, my lord. Illegally acquired property in relations to any person to whom this chapter applies.
Just a minute. I think your case will come in this 68, kindly say 68A double C. 68A double C. Whether your petitioner will come within the ambit of this.
It is exact, correct, Your Honor.
So he'll, the quantity seized in this case is how much total?
My lord, nothing is recovered from my possession.
No,
I am
not
not
from your
connected
possession.
at all.
Not from your position, but say, it says that every person who has been arrested in this case
Yes.
for an offense under the act, which is punishable with imprisonment up to 10 years or more.
My lord, it's a
It means
commercial.
it has to be a offense punishable up to 10 years,
Yes.
at least 10 years. 10 years or more.
In this case, my lord, section 27A, 29, and commercial.
So whether intermediate, a person who has been
commercial-
arrested for intermediate quantity, whether he will come within the ambit of this?
intermediate
68A double C, whether he'll come.
because here this case is of commercial quantity, my lord.
It is a commercial.
It is
quantity.
a commercial-
Okay,
commercial
that,
quantity.
that,
That will
uh,
come.
That is a
that
commercial-
argument is academic.
Yes.
He comes. Okay.
Yes.
Comes.
Next,
Next,
we see the definition,
Yeah.
illegally acquired property.
yes. Suppose it is a illegally acquired property, and the IOS should have informed to the competent authority within the 90 days. 57A says.
That's why I asked this money laundering question. It's similar. The principle is same. You kindly see G1, 68B G1.
Yes, ma'am.
Right side on top, the date is mentioned there with a memo is there, memo number BSN/climb/SR
Right.
slash 2023 oblique
Competent authority
777 dated
administrator
29.
at Kolkata.
Yes. Now, if see the date of FIR, my lord. The page number, again, I'm coming back to page number 27. That is the on 18. But as per the format, on 17, I was arrested and my vehicle was also seized on 17. Counting from the 17 January to 23 to till 29 February, April 2023, that means more than it's 90 days. That is first. As per the feature of property. In
Right.
fact, at that time, I was in the jail only, my lord. I was released in the month of September only. So may I read that section, relevant section?
Section 68.
68H. A notice, which was to be served to me. And in this case, I was not served. So the section says, if having regard to value of the properties held by any person to whom this chapter applies, either by himself or through any other persons on his behalf, his known source of income, earning or assets, and any other informations or materials available to it as result of a report from the officer making an investigations under the section 68E, capital E, or otherwise. The competent authority has reason to believe the reason for such belief to be recorded in writing that for that all or any such property are illegally acquired property. It may be served notice, the word served notice is very important, my lord. May serve notice upon the such persons hereinafter referred to as a persons affected. Now I'm affected, my lord. Calling upon him within the period of 30 days specified in the notice to indicate the source of his income, earning or assets out of which or by means of which he has acquired such property the evidence on which he relies and other relevant informations and particulars, and to show cause why all or any such properties as the case may be shall not be declared to be illegally acquired property and forfeited to the central government under this chapter. My lord, it is very clear. Here I was not served a notice. I should have given a note, I should have served a notice.
Forfeiture
And
of property can, I think generally speaking, forfeiture of property can only be done at the end of trial.
yes, my lord,
Yes.
that's what exactly I
But
wanted
here
to say.
actually they have not exactly forfeited. They have
They have
freezed your
freezed it,
property, which
yes.
means you cannot transfer.
Transfer, yeah.
You cannot transfer.
My lord, I cannot, but
You cannot transfer. Right?
my lord,
So for that also notice is necessary.
yes,
And where is that notice?
they have not served a notice to me. That is why I have come before this honorable court.
Just a minute. Elia Doimari. Which is the relevant provision? That before freezing also you have to issue a notice like this?
That is 68H.
No, that is for forfeiture.
And another
for forfeiture.
aspect is there, my
No,
lord.
that is forfeiture, you know.
Yes.
Freezing and forfeiture are different things.
In the month of February, I was in the jail only. I was not given the opportunity.
Seizure or freezing of illegal.
Yes.
Your relevant provision with regard to this proceeding is 68F.
68H. Because if I'm given an opportunity here before as a natural justice, then if I can satisfy, it's okay. If I cannot satisfy, then definitely they have right to freeze my property.
See, you come to your 53 of your petition, 53. This notice which was given, you know, that notice of freezing, you know, this has been given under 68F. 68F. That's why I'm saying, you know, that it is, I don't think it's a case of forfeiture. Forfeiture can be only at the end of trial.
End of the trial, my lord.
My lord, at least I should have given the opportunity to prove myself. And now it is a time of trial only. Now trial is going on. I'm on a bail. And now my vehicle has been, for no reason, it is in the custody. It will not serve any purpose. There is a Sundarlal Bai case is very standing order is there. At the same time, the Gurvinder Singh's Supreme Court's order is also there. So I'm ready to comply all the term and condition whichever is being enforced upon me by this honorable court, my lord. Because I've till last year, I am paying my MI monthly that installment. In one hand, the vehicle is in the custody. On the other hand, I'm paying my liability towards the financer.
Now, what is the date of this notice? You have the
Yes.
petition,
my lord, page-
page 53 of
Page
this petition.
53. my lord.
53 years.
This notice, what is
That
the
is
date of this notice?
date of the-
68F notice.
Date.
29.
This is not a show cause notice. This is
No, it is not to a so-called notice. It is
freezing of the
no,
property.
this is the,
So
this-
that's why, is there any provision which says that before freezing, notice has to be issued?
Yes.
My
that is
lord,
not-
my lord, that is where
But from no date in this.
in fact, copy was not served to me, my lord. Yes, they have given competent authority after 100 days. That is the gross negligence on their part. The statutory provision has not been complied by the competent, by the this so-called IO.
My lord, I would like to point out one thing. Yes, my lord, regarding that, your
Scan
lordship,
record is available.
case record is, my lord,
We need the, I think. we
no, my lord, case record is not available, my lord.
Need the case diary. I
Yes,
think.
case diary would be required. Otherwise, my lord, yes, this is not that freezing order is not permanent deprivation of his property. This is a temporary measure. Regarding confiscation, my lord, yes, confiscation has to be started after, my lord.
Completion only.
There are also,
Confiscation is always after,
Yes.
but regarding.
without being proved guilty, how can you
Yes.
confiscate?
In this matter also, without proving, how can they seize
And
my?
regarding now, my lord,
Seize they can.
my lord, his grievance is now regarding releasing of the vehicle.
Yes.
That vehicle, my lord, he is an accused in that case. And from the, my lord, present petitioner, my lord, from that freezing order, my lord, whether, my lord, true or not, total more than 100 kg of ganja was recovered from the possession of the present accused persons, and one of the vehicle.
No, nothing is
and,
recovered from.
And regarding one Supreme Court decision, my lord, recent decision, that is, my lord, Biswajit De versus State of Assam.
Vishal De or Vishal.
Biswajit De, my lord, was categorized the
Owner.
four categories, my lord. Under
Hima
what
owner.
circumstances, my lord, vehicle in which is involved in an NDPS case can be released, my lord. And under that category, if
Can be
petitioner
released.
himself is an accused, then he cannot be said that he is entitled for getting the vehicle, my lord, during at this stage. Anyway, my lord, the record is not there, so your lordship may, and that freezing order also.
But this is not a, that's why, it is not a simple interim custody matter.
Yes,
It is
yes.
also, 68F, this
And-
freezing aspect is involved.
Yes.
Both aspects
And
have to be
regarding that
decided.
freezing order, your lordship may kindly peruse page 60.
The learned court below rejected the prayer only because of this reason,
Yes,
that
yes,
it has been frozen.
yes.
And my lord, another important aspect is there 68J also, if you.
And regarding, my lord, notice, serving of notice and giving opportunity to the present petitioner, my lord, your lordship may kindly peruse page 60 of the freezing order. Page 60, last portion, my lord. The person affected was afforded maximum reasonable opportunity. That will come only in
Page
the
60.
page 60, my lord.
60.
60.
Achha.
Paragraph
Quite a
eight,
it's a
eight.
detailed order.
The person affected was afforded maximum reasonable opportunity and sufficient time to submit his reply along with the relevant documents to prove that the above movable property under freeze was not acquired out
Which
of.
para you reading?
My lord, serial number 8, my lord.
Point number 8, serial number 8.
Point number 8, my lord.
Yes.
60.
Mhm.
Before discussion and findings, my lord.
Yes. And prior to that date is there 57 again. But for several times the report has been called, but from their side, we are not getting
Just a
positive
minute.
response.
Para 11 I'm seeing.
What
Freezing
has to be
order.
come from the trial.
Actually, this is the first order we should have seen, it would have made things clear anyway.
Yes.
We've gone through the freezing. order. So that is. Despite them the same property. The difficulty, you see para 11,
Yes.
point 11. There's reference to freezing order dated 8/5/23, passed by the empowered officer. But this order of freezing does not have a date.
Yes.
But
Date-
it can, and it
That is
cannot-
yes, my lord, page number 53 or 57. 57, there is a date.
No, not this one.
Freezing order is passed on 25/5/2023.
Yes.
Page 57, that
57, that
That-
is there, my lord.
is 25/5,
No.
57, my lord, 57.
No, this-
57,
This is the competent authority.
yes, competent authority. In this case also, when competent authority served this notice to me, at that time I was in that jail and I was not in position to go to Calcutta and challenge this order also. So there is a, I've been denied from justice. The bail order is, my lord, page number 64. On 5
No,
9.
that's why I'm saying that there's some confusion. See,
Yes.
you see the last part of the order. Just see the order at page 61, order. See, the competent authority confirms the order of freezing. Confirms the order of freezing. So it confirms the order of freezing dated 8/5/23. Right?
Yes, yes.
And if I'm not mistaken, this is the order of freezing.
Yes.
This at page 53.
Yes.
See page 53. This is the order of freezing, right? You've seen it, no?
Yes, ma'am.
If this order is dated 8/5/23, then how can it be? Because this order, notice, the letter sent to the competent authority to confirm the order of freezing is dated 29/4/2023. I don't know if I understood wrong way, then another
Yes,
matter,
ma'am.
but.
My lord, you're absolutely right.
In that case, my lord, there is no, initially before that, my lord, no notice served.
Yes.
Anyway,
my lord, records may be.
let us get the
Let us
records.
get the records.
Let's get the records.
But I'm sure, my lord, they have violated this statutory provision of
And
57.
And one
A.
aspect is that since 2023, my lord, he has not challenged that freezing order. Petitioner has not challenged in any.
In 24, we have challenged. We are not challenging that. We are challenging now just only for the revision only. And once it is negative, then we will go for that.
He's agreed by the not giving of Jima. That is
Not
the-
that,
Yes.
that is now
Yeah,
not
so,
given.
so that also needs to be
yes.
challenged, sir, isn't it?
Subsequently, we'll challenge that also, my lord.
But that is, the learned court below mainly said that
Yeah.
without because the freezing order prevails, therefore
Yes, since
the Jima cannot be
Jima
given.
cannot be given.
That's
That was contended by the IO. It was accepted by the court.
my lord.
So that point we have to see whether, case laws also you look up, there are not very many case laws on these provisions of NDPS Act. And I'll also look up that you look up this provision that whether two things you have to decide. Now as I understand, two things we have to decide. Whether first thing you have to decide is he's on Jima, right? So whether there is a subsisting freezing order, whether in the face of the existing freezing order, the giving of Jima would be permissible in law first. Discretion is different thing, but whether it will be permissible in law. Number one. Number two is that whether this without challenging this
freezing order.
without challenging this order of freezing, whether the Jima can be looked into.
Yes.
Same thing actually. It's the same issue.
Same issue.
The same issue. These two things you have to go into. And also whether the freezing order was passed following the proper procedure.
My
These
lord.
two issues. Only these two issues are there. Whether proper procedure was followed while passing the freezing order, and whether the Jima will be, order can be made in the context of subsistence of the freezing order. These two issues.
My lord, in my opinion, they have not followed the statutory
Yes,
provisions. I'm 100% sure this.
That is for
Because the date is very clear on record.
Then
I'm 100% sure this, my lord.
Then we'll have to decide the other issue, that
Yes.
whether whether the learned court below was correct in holding that. That freezing order is there, I cannot give Jim. This is what we have to decide. Dewey, learned counsel for the petitioner, who addresses arguments on the matter. But the same could not be completed. I've also heard the arguments addressed by the learned additional public prosecutor. Though copies of several of the relevant orders and documents have been annexed, but for proper adjudication, need is felt for perusal of the case record. So what should we call? Now you can guide. the court.
Special NDPS case number 3/.
Call for the scan TCR of special NDPS case number
3/3
of 2023 from the court of the learned
Biswanath
Special
Sarayali.
Judge NDPS, Biswanath Sarayali. Within bracket, police case, Gingia PS case number 5 of 23.
5/23.
do I need to keep it as part heard because I have written those things?
Your lordship may keep it as part heard, my lord. It would be, my lord.
Matter may be kept as part.
That is
Not
fixed on
waste your effort.
11/11.
The matter may be kept as part of list.
Any date as per the convenience of your lordship.
We'll keep it in admission stage only.
Yes.
List it in the admission column on.
11/11.
Will it come by then?
11,
don't
my lord,
know.
may not, on 18/11, my lord.
18/11.
Oh, 18.
Highly obliged.
Apply to admission or something.
May I please your lordship? Sir, I have challenged the impugned order.
Be an order is there?
Yeah, page 36, my lord, kindly. My lord, what happened? I lodged a FIR, my lord. And it was charge sheeted, but my lord, investigation was not properly done. As a result, the accused person who has misused of my amount, my lord, did not deposited my amount collected. Their bank account has not been seized, my lord. Now, my lord, learned magistrate has rejected my prayer. I prayed for the reinvestigation can be done, my lord. Then learned magistrate has not accepted it and rejected. On this point, my lord, there is a judgment I have annexed, my lord.
Vinu bhai.
Yes. No, my lord, this is the Anand Thakur, Kamsa versus State of Maharashtra. The victim has the fundamental rights of fair investigation, page 23. And therefore, mere filing of the charge sheet and framing of the charges cannot be an impediment in ordering further investigation, oblique reinvestigation, oblique de novo investigation, if the facts so warrant. That is the case of the apex court, my lord. Here also, my lord, since my lord, honorable court below has not accepted my contention and has said that there is no scope for further reinvestigation of the matter, it was rejected, my lord. I have challenged that order.
The impugned order is this one?
Page 36.
12/8/25.
Yes. Court said that it will adversely affect
He has relied on the Vinu bhai case.
Yes.
That since trial has commenced, so there is no.
No. Trial has not commenced. Only charges
Charges have been
framed.
framed.
And Supreme Court has clarified in this case, even if charge is framed or even trial also, my lord, at any stage, that judgment I have annexed, my lord, victim has the fundamental rights. Therefore, the mere filing of charge sheet or framing of the charges cannot be an impediment in our ordering further investigation. The judgment of 2023, my lord.
This Anand Thakur.
Yes.
Yes. Anand Thanur. Okay, we'll have a look, but the time is already up.
But if your lordship go to the FIR, my lord, your lordship will find
So, but
allegation is very serious.
assuming that, this
Like
Binu
50
Bhai,
lakhs rupees involvement is there.
Binu Bhai says that, he has relied on this,
Yes,
says that after charges, after trial has began, after trial has commenced, then. he
Trial has
cannot
not commenced, madam.
Order further investigation and, holding that, since charges has been framed or the stage of trial has started, anyway, that's different. But suppose whether this judgment, subsequent decision, Anand Thanur, that fundamental right, will it still prevail over this power of the magistrate to direct further investigation after the commencement of trial then? Because
Yes.
we have to see how to reconcile these two judgments. We have to see the bench strength. Anyway. Should we admit it or should we keep it at admission only?
But your lordship may pass the order so that the other it will delay it again trial, madam. That's all. If once admitted, to remain pending.
Because today we are almost up against the time. So what do you say?
On admission column then, my lord,
Again,
in another date, my lord.
Heard SC Biswas Learned Council for the, was taken the court through the impugn order dated 12/8/2025. Where the prayer of the, you are the informant, right? Petitioner was the
Yes,
informant.
he informant. That's
Prayer
right.
of the petitioner as informant before the learned trial court seeking further investigation was disallowed. Full stop. Also heard learned additional PPK Boyso. List the matter again on so and so in the admission column.
And it may be kept at part heard also, madam.
Part heard, not necessarily because this is very preliminary. Very preliminary. That line लिखित हो पड़े for the guidance of suppose it comes up with another one. The learned JMFC, while passing the impugn order dated 12/8/2025, has also relied upon the judgment of the Honorable Supreme Court in the case of, page 37 or 230, Binu Bhai, Hari Bhai, 230. That will be further guidance. List the matter on so and so date in the admission column. You can suggest a date.
My lord, item 46.
Just a minute.
Date to date.
Fix the date.
Any date I have got no objection, madam. As per your convenience, madam.
14/11,
14/11, something like that.
Well,
hearing 14/11.
14/11.
Okay. Now other matters, mention matters.
Item 46, 395 days I am in custody. Only 5 years conviction, there are so many judgments.
46?
390
Order matter.
Order matter, bail.
I'm having a problem with admission and orders. If I take up orders first, admissions
Yeah.
don't reach. If
No,
I take up
my
admissions
prayer is
first,
that-
orders don't reach.
My prayer is that it
Both are
can be
important.
taken tomorrow, my lord.
Both are important, personally.
Maybe taken,
Tomorrow again, it will be in the supplementary list.
yes, no problem, my lord.
Supplementary
Because,
list. After admissions, it may not.
because 395 days I am in custody. And similar cases, almost all the accused persons have been granted bail.
So only tomorrow.
No,
my lord.
tomorrow lot, 62 matters already listed tomorrow. Tomorrow, let's leave tomorrow. Friday again, it will be in the long list.
My lord.
We
The
can
next
take-
week, any date,
Take
my
a,
lord?
take a chance on Tuesday,
Tuesday?
hearing day.
Yes, my lord,
No,
hearing day.
In the, it will come, it will up,
My lord.
then we can take up this matter
My-
before starting the normal hearing,
My lord.
right?
Then item
That-
46 may be taken tomorrow, on Friday. This is very matter, my small matter.
46, no?
Yes.
No, 46, you're
46
you're
is
mentioning 46, right?
Yes,
46, let it be on Tuesday.
Tuesday.
Paucity of time is the matter on Tuesday. Key tarikh hoga Tuesday, 28. 28. Hearing day, there may be some chance of taking. Otherwise, I am seeing this. We take this orders, the admissions don't reach, and I have tried taking admission. The orders are not reaching. So anyway, 46 on Tuesday. Next.
I would like.
Mention.
My lord, I beg to mention item number 23, my lord. Here, my lord, the POXO matter, my lord.
23
Here, yes, my lord. Here, my lord, the informant is appeared, my lord.
for the
But my
revision
lord,
matter.
But my lord, here, my lord, the lower court record, my lord, that has not been called for, my lord. So I prayed that the LCR may be called
Yes.
for, pro registry, my lord.
23. The LCR, sorry, not LCR, the scan case record may be called for from the learned court below. Particulars can be available.
My, special POXO case number 19A/2025,
19A.
my lord. In the court of my lord, Special Judge North Salmara, Abhaipuri, my lord.
Abhaipuri.
Abhaipuri, my lord, not Salmara, Abhaipuri.
Abhaipuri likhe aap.
My lord, in this matter, we want to make a prayer, my lord, if my lord allows. My lord, in this matter, my lord, somehow, my lord, we lost the, my lord, the petition copy. If my learned
Fresh
friend-
copy maybe.
I'll, sir,
that
sir.
we have to-
Petitioner shall furnish a fresh copy to the
My-
prosecution.
my-
Obliged, my lord.
Deeply obliged.
Date, you take the date,
The date, my lord,
list on
next month, my lord, first week, my lord.
no, not first week, let it be 18 November,
18,
1811.
18.
Okay.
deeply.
25 matter.
May I please, your lordship? Lordship, item number 47, lordship.
Hmm? No, if we fix it, it will come, otherwise they will also fix it. Otherwise, if we don't give date, they will give.
LCR pro registry, my lord.
Yes, true this, true this.
Lordship, today matter has come up for
Yeah, it
consideration,
will have
suspension
this.
of sentence and constitution of bail, lordship. And as on today, lordship, he was 2 years, 10 months, 16 days, lordship.
Out of total
Out of 10, lordship.
10 years.
Lordship, he was convicted for under section 304B as well, read with 306, lordship.
Can it be on
Tomorrow, lordship, at 2.
tomorrow, lots of matters. Impossible.
Next week, my lord, any day.
Somehow, I don't know, though hearing this, somehow a lot of matters has got fixed.
Or lordship may fix Friday, lordship, because he is seriously in lordship, jail, lordship.
Friday I can fix, but again, no assurance of reaching because it's a motion day. After admissions and all, or today I could not start orders also,
Lordship.
right?
Friday, lordship, take a chance.
I would suggest you to take Tuesday onwards.
My lord.
Tuesday, take it Tuesday. Okay, Tuesday, or you want it on Friday?
Friday,
Oh,
lordship,
Friday.
take a chance.
List on Friday, 24.
At 2, lordship, if,
No, I cannot fix.
then
it.
lordship, Friday,
Normal
lordship,
course.
Friday, lordship. Deeply obliged.
We also have a hearing method to that.
Yes,
14.
yes.
But it will not reach, never reach. Yeah.
Matter item 22, which is supposed to be taken up the next matter, matter. It's a Zimma matter. Matter, November, matter, second week if possible, matter.
Was about to reach, but got no time. Paucity of time, 22, item 22. This is the matter in November.
Any comment? 18th, matter.
When you suggested?
18th, matter.
18th November.
18th.
18th 11.
I'm deeply obliged.
Anything else? No.
My lord.